That is default. My lord, I beg for mention, my lord. Listing of matter, my lord, for admission.
What matter?
Pension matter, my lord. Pension.
Pension?
Yes.
For? Pension of what? Who?
Worship.
Whose pension?
Retirement pension, my lord.
I don't take up the pension bench.
Bench. Bench from
Pension bench is bench number 2, 3, 4.
bench from
2 and 3. Pension bench is not 4.
like
Lord, I have to pray for listing of a motion tomorrow, my lord, pertaining to debarment without notice, my lord. Debarment without notice, my lord. Deeply approved.
Borodrel, item 16.
Withdrawal.
For the PWD MFL.
Why is it thought to be withdrawn? Tell the counsel for the petition. After taking this order, he has been withdrawn. Take it up sumo to this matter. Cannot allow him to withdraw. There is a substantive question involved. The PWD as well as the departments taking into account the site visit certificate have been committing illegalities right, left and center.
Pardon, Your Lordship, pardon for the delay. With the consent of the petitioner, I would like to withdraw this case as the
You cannot withdraw this.
Sorry?
I'm not going to give you the leave to withdraw. Will appoint an amicus. Matter remains as it is. Yes. You file your affidavit.
Lordship.
List the matter. Where is Mr. K. Bhuya?
Your Lordship.
Where is he?
We just arrived at court right now. We just arrived at court right now.
Huh?
We just arrived right now. He's getting.
Ask him to come.
Yes, okay.
Item 10, fixed at 10:30 a.m.
Yes, what is your case?
My lord. My lord, here in this matter, my lord, that certain clause are important, my lord, clause 5.14 at page 52. It is an essential clause. It appears, my lord, that non-furnishing of those documents with the bid, my lord, calls for rejection of this bid, my lord, page 52. 5.14. Bid received without attested self-attested copy of registered deed of partnership specifying power of attorney in case bid is submitted in the name of partnership firm will be rejected. Now, pursuant to the order of the Honorable Court, they file one affidavit. In the affidavit, they says these documents, my lord, partnership deed, power of attorney, they have produced later on the basis of email given to them. These documents are lacking, you produce it. And they produce those additional documents, my lord, on 1/2/2025.
Last date for submission?
Last date of submission, my lord, 20/12/2024.
And when did they submit?
My lord, they have been given the opportunity by email dated 30/1/2025, page 93 of the writ petition, my lord,
And they submitted on,
on 1/2/2025. And these are the documents, my lord. Partnership from power of attorney.
so that is your case.
Now, while giving such a opportunity to the respondent number 3, my lord, I also sought for some opportunity because out of mistake, I was suffering from my eye problem. I could not personally, my lord, look into while uploading the files, and I missed one file whereby my turnover was not uploaded. Therefore, my lord, I submitted my representation, hard copy, my lord, on 10/2/2025 at page 90.
For,
Page 90, my lord. This is the hard copy, my lord. My lord, third para, my lord, let me read, my lord. Unfortunately, on 18/12/2024, I was suffering from migraine pain and withering of eye problems. So I went for the checkup and my doctor advised me to avoid screen exposure for 1 week, due to which I was unable to supervise personally while submitting the document. As a result, I requested my own brother to submit the tender on my behalf using my system, but he mistakenly uploaded the incorrect PDF file, did not contain my financial documents.
then you sent an email, na?
Yes, my lord. Because on 20, my lord, they have rejected me 28 February, page 92, my lord. It should be dated 22, my lord. Because I print out the letter on my 19/3, therefore it is reflected 19/3. This annexure 8, my lord, page 92. It should be dated 22/2025. My
Where,
lord,
page,
page 92, my lord. Because left side corner, my lord, it is 399 downloaded then, my lord. However, it should be 20 February. Reference to subject tender number so and so, your techno-commercial bid against the subject tender has been evaluated, and after scrutiny of the same, we regret to inform you that your techno-commercial bid due to non-submission of financial document as per clause 4.0 BEC BRC of the tender. We thank you for showing interest of our tender. If you have any representation above the subject of your bid, it is important, my lord, please reach out to the undersigned within 22nd of February 2024. My lord, pursuant to that, they have given me one opportunity while rejecting, my lord. I'm thankful for them, my lord. And on 20 February itself, I have, my lord, submitted the email. My lord, in my additional affidavit, page 137. Page 137, my lord. This is my mail pursuant to the rejection on 28th of February, my lord. The same representation which I given the hard copy on 10/2 that has been, my lord, put it now pursuant to their request. 137. I recently received an email from your concerned authority, bid number so and so, other relevant correspondence about the said tender submission documents in Oil India Limited, and I had not submitted the required financial document, turnover net worth certificate. However, I'd like to clarify that I had duly submitted the necessary financial document actually during the first submission of the said tender, which was on.
Yes, Mr. I Chaudhary, what do you say about clause 17.4.3 of those materials that day you showed, na? In another case?
No, here, the facts are like this. In fact, my lord, I entered at a much later stage when the affidavits were filed. There are some facts which ought to have been brought on record. Those unfortunately were not brought on record. May I place the facts, one?
No,
What?
what do you say about clause 17.4.3? Not
Clause-
here. You materials procurement.
Yes,
That day you showed me a document.
that is pertaining to,
No, same
No, that is pertaining to ONGC. This is Oil India Limited.
Or this is oil in.
Here, the clauses are slightly different.
Okay.
What has happened is like this, my lord. We required 156 number of units. There were 100 tenderers. So the process is that we do a draw of lots and make a sequence 1, 2. If there are 100, we make a sequence 1, 2, 3, 4. It goes on. All these 100 are put in a sequence. And thereafter, the documents are evaluated. Once the documents were evaluated, we found that our circulars say that if the financial documents like turnover, net worth, etc., are not furnished by someone, then we cannot do anything about it. They have to be rejected. However, there are clauses in the tender also and in our procurement manual that in respect of other clauses, we can ask for clarification. Here, what had happened was, in respect of not just the respondent number 3, there were 22 such tenders where we found that we can, these are not pertaining to turnover and net
Where
worth.
is the document which says that financial cannot be taken?
My Your Lordship will kindly come to the additional affidavit filed by Oil India. Page 146. Your Lordship will find serial number 1. Bidder has not uploaded any financial documents in e-tender portal as per NIT, or bidder has not uploaded any financial documents in e-tender portal as per NIT. However, they have only mentioned complied undertaking and balance sheet enclosed or complied in the compliance sheet for technical and financial criteria. In the right hand side, Your Lordship will find for points 1 and 2, where bidder has not submitted or uploaded any financial document, we will not ask for further submission of document. It will be rejected.
So
straight.
you say that this particular document will override the tender condition in 5.14.
No, 5.14 is pertaining to something else.
That's for partnership. deed.
That is for partnership deed, etc. So, in respect of financial documents, there is a strict bar that we cannot ask for any clarification.
But do you have it, similar terms out there in your tender?
No, this is not, this,
In your tender, is it mentioned that they will follow as per this executive?
no, that I have to
instructions?
candidly admit, my lord, that it is not mentioned in
So
the.
then how can you rely on this? document?
What I'm on is, rightly or wrongly, my lord, 22 such tenderers, we gave an opportunity. And those tenderers, they submitted their clarifications, and respondent number 3 happened to be one of those 22. And once these documents were found to be valid, because he had mentioned in some place that he is it's a partnership firm, but he had not submitted the documents. So we asked for the partnership deed and the power of attorney. Once he complied, we, not just him, again, other 21 also.
But that was categorically stated in 5.14, you cannot ask.
But if your lordship will kindly come to one clause,
We do
that
one
is,
thing.
I cannot improve upon
No,
the
no,
case.
we do one thing, we set aside the entire tender process.
My lord,
Entire tender process.
your,
Not against him, against all, because 22 have been given, whereas the petitioner has not been given the opportunity.
my lord will
On
kindly,
the basis of a circular, which is not a part of your tender document,
my lord will,
we set aside this.
your lordship will
Mr.
take a call, man.
Vedas. No,
Let me just place the facts on the,
no, fact is understood.
and
I've heard that.
my lord will
Heard
just,
Mr.
my lord will just allow me to place 1 or 2 judgments, man.
No, judgments are for the division bench to look into.
No,
Mr. Chaudhary, I'm not going to look into any of the judgments. Judgment is for the division bench or the Supreme Court to look into.
ultimately your lordship will take.
Here is a case where there is been a complete on as regards 5.14, you are not following, which is a part of the tender condition. The tender condition do not mention anything about that circular.
Right.
You are emphasizing on a circular on the basis of which you are not going to give it to the petitioner. However, for 22 other persons you have given.
Given.
So the entire tender process has become
see
faulty,
it.
for we set aside the entire thing.
My lord will just allow me to place 1 or 2 clauses and
Yes.
the judge. Otherwise, your
Show me only one clause
Your
which
Lordship-
says that you can rely on that document which is being issued by the executive director
my,
in the tender condition.
I'm on that, I'm candidly mentioning, my lord,
So
that
then we
it-
cannot look into that
no,
document.
I'm not,
But if you are relying on that document on the basis of which you are saying that we are not going to take his financial document, then this is absolutely bad.
but
Either take his document and proceed or don't do. How many units did you apply for?
my lord, two numbers
Oh, then
only.
apply and do it.
Yes,
That is the only way. You
and
cannot
moreover,
have
the
a-
submission has
just
come,
because
my
of
lord.
him, we take up, you dig out one of 2018, some document from 2018 and you say.
no, it
that
is
we-
not just him, my lord. There are 5
But
others.
in respect,
These are,
5 or 10, whatever may be, that is the entire thing has been.
these are
made,
pre-existing document also. And
It is
moreover, my lord, that
absolutely
submission has come, my lord.
My lord will, your lordship will, ultimately your lordship will pass the order, my lord. I'm just praying that, let me place the facts, my lord.
The facts are very
Yeah,
clear.
your lordship
He
will just-
applied.
Just,
Let me tell you the facts. The facts are very clear. He applied in pursuance to a notice inviting tender. He did not submit his financial documents. His case is that, look here, I was suffering from migraine or whatever, not, and I could not submit. If you had not taken into consideration others also, there's no question, he should be debarred. But here is a case where, in spite of there being a clause 5.14, you have allowed the respondent number 3 to submit those documents, but did not care to allow him, more particularly when prior on 10/2/2025 or 4,
Yes,
he had duly submitted this email, and thereafter you say that we have rejected you on 19/2 or 19/3.
my lord, 22.
It is absolutely
Yes.
unfair.
my lord will just allow me
Remaining for the division,
Uh,
for you to file that.
two judgments, my lord.
The judgments is for the division bench to look. I don't look.
Your lordship will just make a reference to those judgments. my lord. Ronak and JJ Fernandez.
Not necessary.
And
Ronak's-
this is a composite bit, my lord, that the.
How is Ronak,
Already fixed.
how will Ronak have any implication?
Ronak, well, para 27 has an implication.
How?
Ronak says that at the instance of an ineligible bidder, interference will not be caused. That is
He
the first principle.
And then at the
He was also.
at the instance of an illegible bidder, he would therefore be not entitled. But at the instance of an ineligible bidder, if another illegible
Illegible.
bidder is being given a preference, then he will be. And if the Supreme Court says otherwise, go to the Supreme Court for that.
But,
But
and your lordship will also take note
Ronak does
of
not-
para 15 of JJ Fernandez. well.
DJ Fernandez is an old law. Okay, now let me dictate.
Your lordship will just make a reference to those.
No. The reference is for the division bench. You may very well tell the division bench, look here, this single judge did not look into it.
My lord,
We set aside the entire one.
my lord, your lordship will kindly see the prayer. The prayer is only specific to respondent 3.
No, we said that you, on the basis of your submission that you have allowed 22 persons, but not the petitioner. This is absolutely a case of action being taken by you only to favor those people who are in your good books, not the persons. like-
Certainly not, my lord. Those are not even pleaded case.
No,
That is not even a pleaded case.
I don't know them.
No, isn't it your case out here? There is a violation of Article 14.
Yes, that's my case, my lord.
To the extent of,
And moreover.
your lordship will,
And you must have seen a very recent judgment of the Supreme Court.
And in fact,
wherein while
consider.
dealing with the case out there pertaining to Mohinder Singh Gill,
Yes.
the Supreme Court say that although Mohinder Singh Gill says on the basis of that order, you need to, the reasons stated in the order, you are to look into it. But then also, if from the documents one can make up, that on the pleaded facts one can make up, that there is the violation.
It's a
of
vicious.
this court
Yes.
under 226 to exercise it.
And Lordship has rightly, my lord, pointed out that also in the recent case, my lord, Bongsidhar Construction Private Limited, there also same thing happened. While relaxing a particular condition, clause number 10 in favor of respondent number 8, and that was not given to appellant. And therefore, Supreme Court set aside entire tender proceeding directed for fresh tender.
Right.
2024-10 SSC, my lord, 273.
Yes.
That's the case, in my case, present case also, my lord.
set aside the entire tender.
My lord,
In that case, my lord, because your lordship will kindly,
Either consider, only thing I can hear is you will consider him. Then only thing.
yes, we can, my lord. We
Then
can.
if you
As
consider
soon as we,
him,
your lordship will.
Then
Your
on
lordship will
the
cal-
basis of an undertaking given that you will consider him, I will not.
Your
consider.
lordship will fix it tomorrow, my lord. I'll have a instruction on writing and we'll-
Else, it is going for a allowing the refund.
my,
at
we can. Your lordship will kindly consider one thing. There are 156 tankers which are in operation. Contracts have been awarded way back, 2-3 months back. Now, if it is interfered with, even if your lordship sets aside respond number 3, then against that, we will consider it.
The entire tender process.
No, your lordship will kindly see. Your lordship will kindly see. It upsets the entire.
Maybe, but the problem lies with the department wherein they have gone for all illegalities.
But it
They
is.
have picked and choose that those
Yes.
persons who are there, in spite of
So
there being a
Art
clause
14.
5.14 debarring, you don't rely upon that, but you rely upon a document which is not a part of this tender documents.
Yes,
So, on the face of it, that you are just picking and choosing your people and giving it to them.
It is.
Oh.
Look,
I
Had it been a case of pick and choose, it would have been only respond number 3.
that your additional affidavit which you have filed recently also categorically shows
Yes.
that you have vindictive against the
Right.
petitioner, that you are not going to give on searching out a particular document which is must be lying in the trunks out there and finding it out. Oh, 2018 we have a circular. Although there is no mention in the tender document.
It is.
not notified.
Your lordship is absolutely right. It has.
Otherwise, why on earth you did not mention that aspect out there in your rejection of the tender document?
Right, not.
Why on earth you did not mention about that in the at the time of filing of your affidavit? Why? The reason is that you need to pick and choose somehow or the other. The petitioner has to be debarred.
Right.
This is absolutely in
So
violation of Article 14.
This is about.
I tell you,
It is. Had it been
either
singling
the
out.
department only way that allow the petitioners, if he is otherwise eligible in respect to other documents, give it to him if he produces the financial. Otherwise,
Your lordship will, in that case, take it up tomorrow. I'll have the instructions and come back.
heard Mr. P.K. Das, the learned counsel, appearing on behalf of the petition. Mr. I. Chaudhary, learned senior counsel, assisted by so and so, appears on behalf of the respondent numbers 1 and 2. The present case has been filed by the petitioner being aggrieved by the unfair treatment, unfair and discriminatory treatment meted out to the petitioner. Inasmuch meted out to the petitioner. The grievance of the petitioner herein is that on account of certain difficulties beyond the control of the petitioner could not submit certain financial documents.
Which are pre-existing documents.
Huh?
Which are pre-existing documents.
Which are pre-existing documents, not necessarily
Malum,
financial documents.
malum.
The counsel appearing on behalf of the petitioner submits that on that ground, if the petitioner's bid would have been rejected, the petitioner would not have any quarrel. However, the grievance of the petitioner herein is that on one hand, the respondent authorities have chosen not to accept those financial documents of the petition, but on the other hand, have granted, allowed the respondent number 3 to submit certain documents which on the face of it was barred in terms with clause 5.14 of the tender documents. Today, while carrying out the hearing, The learned senior counsel appearing on behalf, Mr. I. Chaudhary, the learned senior counsel who appears on behalf of the respondent number 1 and 2 had submitted that certain documents can be accepted, but certain documents cannot be accepted. Basing upon a circular, a communication issued, an office order issued by the executive director of the respondent number 1, dated 16/2/2018. The learned senior counsel therefore submitted that as the financial documents cannot be accepted, the petitioner cannot be given a further opportunity to submit the financial documents. Whereas other documents can be accepted. This court inquired with the learned senior counsel as to whether the circular, which was only for internal use purpose, as is mentioned in the circular itself, was ever brought to the notice of the tenderers, in as much as whether the tender terms refer to the circular in question. The learned counsel, senior counsel appearing on behalf of the respondent number 1 and 2, with all his fairness, submitted that the circular has not been made a part of the tender conditions. The learned counsel further submitted, the learned senior counsel further submitted, the like the respondent number 3, 22 others have also not complied, but opportunity was granted. A further submission has also been made that the instant writ petition was not maintainable at the behest of the petitioner on the ground that the petitioner was not an eligible tender bidder. The said submission is on the basis of the judgment of the Supreme Court in the case of IVR Ronak versus, what is that?
IVR International versus Ronak.
Ronak International.
Ronak International. What is it? Ronak, what is it? Ronak International Limited versus IVR Construction.
IVR Construction reported in 1990
99 1 SSC 492.
on HCC page
492.
490 and referred to paragraph number 27. The propositions as set out in the said judgment is very clear that an illegible tender bidder cannot question the tender process. However, that said ratio would not apply in a situation when an eligible tender bidder questions the decision of the authority to grant preferential treatment to another eligible bidder. This whole prima facie is of the opinion. Having heard the learned counsel, the prima facie. No, this court, upon hearing the counsel's find that prima facie it appears, no, this court, upon hearing the counsel, is prima facie of the opinion that the petitioner herein have been not given, have not been, the petitioner herein, who is similarly situated with the other bidders, have not been equally treated. In as much as 22 other bidders have been given the preferential treatment for furnishing documents pursuant to the last day for submission of the bid. Mr. I. Chaudhary, the learned senior counsel, upon submits that he would like to obtain instruction as to whether in the present case the petitioner can be given a further opportunity by taking his documents, his financial documents, subject to all other parameters, subject to the petitioner being eligible in respect to all other parameters of the tender document. Taking into account the above, list this matter tomorrow at 10:30.
Obliged.
All right.
May I please, Rashid, my lord, I finally withdraw.
Yes, why have you sought for withdrawal?
No, Rashid, because online submission be already been expired.
And why did you move it?
And there is no any interim order. And now, my lord,
They cannot be
now, my lord, the
interim order.
petitioner called me, petitioner, my lord, told that he also approached before the commissioner, civil executive engineer. And civil engineer said that no provision is there because already been closed on online submission.
No,
And
actually-
my mistake, my lord, I have not mentioned the case to take advance. This is my bona fide mistake
No,
because
that is a mistake, it's okay. But the question here is a bigger consequence.
Rashid,
If you were unjustly deprived of the site visit certificate,
that's
the respondent authorities are bound to compensate you as it is a constitutional court. Have you seen my order?
no, I have seen, but party not interested because he said that already it expired. So
Wait,
in fact, so
But this will
so he
allow you to
should
withdraw
not be, shouldn't be continued.
subject to cost of 50,000.
No, because withdrawal, my lord, anytime petitioner is at liberty to withdraw matter. And
With cost of 50,000, petitioner is not at liberty to withdraw. See, a petitioner filing a writ petition is not at liberty to withdraw. You
And-
cannot withdraw. It is at the pleasure of the court. So we impose a cost of 50,000.
but question is, my lord, as no interim for given. and
No intent
no
have been
benefit, no
passed.
benefit obtained from this
But
court.
the issue involved is a
And
bigger issue.
petitioner, my lord, unnecessary, my lord.
Mr. B. Chaudhary, B. Gogoi. This is the case pertaining to site verification.
Side.
He filed the writ petition on 6/9.
My lord.
He applied on 4/9 along with geotext photographs.
Yes.
5/9, he requested, 4/9, he requested the executive engineer. The executive engineer did not give. 5/9, he requested the chief engineer. The chief engineer did not give.
My lord.
6/9, he files the writ petition with advance copy to the PWD department.
But
Then
this-
also they did not give. On 10/9, the last date was there. And the matter came up before this court on 15. Now he could not submit. So I've issued a notice that whether this deprivation to the petitioner would not amount to a constitutional tort. And asking the officials to answer. Because this has become a menace with the PWD department. They have taken it as a handle by which they can do whatever they feel like. They may choose that, okay, I don't like this particular person, I'll not give it. And he is compelled to come before us. Every time I've already disposed of around 8-9 matters of this.
This particular clause has been, my lord, recently added, my lord, 7.1 for this type.
Clause has been added thinking that this executive engineer or whoever the concerned engineer, the word used concerned engineer,
Yeah,
would be a fair, neutral, unbiased person.
lordship.
But these people are taking advantage of this. Here the petitioner herein
My lord.
has lost out. But don't you think the petitioner, this case should be taken up on a two-matter basis, taking into account that this has become a menace? Unnecessary litigations are coming before this court unless you withdraw this type of clauses.
My lord, then my lord, work order shall not be issued in the meantime. Then my lord, it will continue. Otherwise,
Work order cannot be,
I will not get
Right.
any benefit.
you will get the
otherwise-
benefit.
But
You'll get the
Because
profits.
work order is going to
You-
be issued. my
You
lord.
will get the profits. All the profits which you have otherwise been deprived of, the concerned engineer will be paying from his own pocket. Why don't you take that? Don't withdraw. You take it up on the basis that this is a clause, either you have to modify this clause or do something. That concerned engineer's certificate should not be. Why do you need? That day, another thing came up that there has to be a PWD official also.
That part, that's why I said, my lord.
And in number of cases, it is
You
happening.
know, this is in every case where the government or the executive engineer does not want a particular person to submit the bid, they cause the interference to the site visit.
Intentionally.
Lordship will proceed after vacation, my lord, will file affidavit. At
They
least
told-
in this case, they will have to justify why it was not issued, despite having all these documents. Because
Don't withdraw, Mr. Bhuya. Don't withdraw.
Lordship.
You do it pro bono, but don't withdraw because this is a menace which has happened. Let them come up with a justification why, in spite of giving the geotech certificate, when clause 7.1 does not say that it has to be that in presence of a PWD official. Why they did not,
It is a mandatory clause.
let them file an affidavit, we'll take it up. Because this has to stop, otherwise this clause 7.1 has to be struck off. Because they are treating it very arbitrarily, this PWD department. Because in all cases, the allegation is either the executive engineer or the particular principal. In other cases, there are some principals also. They say, get a recommendation from the local MLA or MP.
Yes.
This is what it is. These are allegations which we get it right, left, and
And now executive engineer favors somebody else.
yes, that is the
That's
reason
why.
why. Don't withdraw.
That is, and some other case also pending, my lord. You take care of this.
Then all other cases I disposed, whichever I had. I gave the order on the motion day itself.
Now, this honorable court also passed some favorable order in favor
Yeah,
of the
but
petitioner.
you came late. But this is what has been accepted
But
because
I'll-
let them file.
File
Because you have
proper
given.
time. But
file-
listed, my
yeah,
lord, listed
Let
late.
them file this.
no, my lord, if there is some urgency, he can always mention before the honorable court.
Yes.
Lordship has taken up unlisted motion. my
Because
lord.
during,
He filed it in 5. He was waiting that it
Five,
will
no, he filed
automatically.
it on
but
6.
but some
So on
vacation was there during Sunday, Monday, some
on
vacation
5th of
was there.
September, he has filed, my lord.
Time-
That is a
Time
Friday,
not favorable.
5th or 6th.
6th is
Six,
filed
yeah,
it.
is-
Seven
Matter
and
came
seven
up-
and eight, 7 and 8.
Matter should have come up on 8-9.
Yes.
Matter did not come up. He did not mention it.
You should have mentioned, my lord, considering the urgency.
But are you justifying?
No, I'm
the
not justifying
conduct
that
of The
part.
respondents on the basis of the fault of the council. It is his turn. It is
No,
not
I'm
fault
not
of
on
the
that, but
petitioner.
at least, my lord, you should have taken that, my lord, precaution, that, my lord, that option is there. Provided by this honorable court, my lord, in the High Court rules.
Case
So
was
it is
filed.
his fault.
That's why I'm saying, not
Case
of the
was filed
petitioner.
on time, my lord. Case was filed on time.
For that, he cannot blame the registry.
Is it that thing that you every time, is it your submission that every time you require an order from the court so that only you are going to issue? Make that submission, we'll record it, that you require an order along with the site visit certificate and order of the High Court. Make it a clause out there.
No, I am not on that, my lord. That I'm
Add
saying.
another clause out there. This cannot happen like this. You have to do something as regards this.
Well, I will have the instruction why it has not been issued, my lord. Yes.
List this matter on the
Date-
date so fixed.
Date already given, my lord.
27/10/2003.
My lord, you want to do it?
Yeah.
Earlier, the date was fixed on 27/10/2003.
My lord.
He came up for withdrawal today,
My lord.
but Mr. K. Bhuya will do this as pro bono.
No, Uddal mention may be cancelled. Uddal memo might not, may be rejected. Matter will maybe continue.
Mr. K. Bhuya, the learned counsel appearing on behalf of the petitioner, submits that the petitioner, although had submitted for withdrawal of the instant petition, but
By,
taking
by, by telephonic fault.
although had wanted to withdraw, but taking into account the larger interest of the people, of the bidders, he would not like to withdraw in as much as by virtue of clause 7.1 of the tender conditions, which are now being incorporated by the Public Works Department. The concerned engineer have resorted to gross illegalities. So taking into account the above, the instant matter be listed again on the date so fixed.
Obliged, Lordship.
Item 17, fixed at 10:30 AM.
Yes,
Lordship, no show cause was served.
so we set aside this. Why didn't you take necessary steps? earlier?
Lordship.
No.
Otherwise, Lordship,
Therefore, heard Mr. I. Alam, the learned counsel appearing on behalf of the petitioner. Mr. S.R. Borua, the learned counsel appears on behalf of the respondent. The petitioner herein has approached this court assailing the order of suspension dated 22/7/2024,
My lord.
as well as the
My lord, I have also.
appellate order dated 1/2/2025,
My lord, I have prepared a list of date for your lordship's convenience.
not necessary, as well as the order dated appellate order dated 1/2/2025, whereby the suspension order has been upheld. On 16/9/2025, when the matter was taken up, Mr. I. Alam, the learned counsel appearing on behalf of the petitioner, submitted that the continuation of the suspension order dated 22/7/2024 beyond the period of 90 days without issuance of any show cause notice, as is mandated under clause 15(2) of the Assam Public Distribution of Articles Order 1982, is itself a violation for which there is a requirement for interference with the suspension order dated 22/7/2024, as well as the appellate order dated 1/2/2025.
My lord.
Upon such submission being made, this court asks Mr. S.R. Borua, the learned counsel who appeared for the respondents, as to whether any show cause proceedings was initiated by the respondent authority pursuant to the suspension of the petitioner's fair price shop. Today, Mr. S.R. Borwas placed an instruction issued by the Court District Commissioner Lokipur dated 17/9/2025, wherein he had categorically mentioned that no show cause notice have been issued. The said instruction is kept on record and marked with the letter X. In the backdrop of the above, this court finds it relevant to take note of clause 15 of the Assam Public Distribution of Articles Order 1982, and the same is quoted herein under. A reading of the above clause, more particularly subclause 2 of clause 15 of the said order, order of 1980 order, could clearly show that continuation of a suspension beyond 90 days without a show cause notice cannot be permitted. Because in the instant case, as the suspension order was on 22/7/2024, and till date, there has been no show cause proceedings initiated, this court, in view of clause 15(2) of the order of the 1982, sets aside the suspension order dated 22/7/2024, as well as the appellate order dated 1/2/2025. Before parting with the record, accordingly, the writ petition stands allowed as above. Before parting with the record, this court, however, observed that the setting aside of the suspension order dated 22/7/2024, as well as the order dated, as well as the appellate order dated 1/2/2025, shall not preclude the respondent authorities to issue a show cause if they consider, in the circumstance, the respondent authority considers it necessary.
Lordship. Obliged, Lordship.
My lord, my shop may be restored, my lord.
What?
My shop may be restored, my lord.
It's not, it is not. I have removed the suspension order. There is no termination.
Obliged.
Plus,
Almost on item 18.
Observed that in view of the suspension order, this court for before party. Mr. I Alab, the learned counsel further submits that by then order dated 16/9/2025 in WPC, the earlier WPC number,
WPC number, my lord, 425. 40025.
public 2024.
I have a copy, my lord.
You got my order earlier order? Tell me the number, I remember the. Dated 400/2025, this court had observed that appropriate directions would be passed for
Yes.
appropriate orders would be passed. If necessary, if the beneficiaries of the petitioners are detached from the fair price shop. There was no detagging, huh?
Not it.
There was a stain on that
Stain.
day. It has been submitted that during the suspension, it has been submitted that in view of the interim order passed in WPC number 400/2025, there was no detagging of the beneficiaries of the fair price shop of the petition. Under such circumstances, the respondent authorities shall continue with the fair price shop with the beneficiaries which the petitioner had tagged with the petition, were tagged with the petitioner's fair price shop as on the date of suspension of the petitioner's, as on the date on which the petitioner's fair price shop was suspended.
But perhaps, Lordship, that before suspension, he was tagged with another fair price swap beneficiary. Because they, after their, some complaint was regarding other fair price swap holder, their beneficiary were tagged with his fair price swap, but that was detached.
But you have not taken any action. You should have taken some action.
My lord,
No, I am not on that. Because Lordship, that the beneficiary as on date, till the date of suspension order, as if Lordship, he is having the beneficiary of.
This court further observes that the petitioner hearing would be entitled to this court further observes that in view of the suspension order having been set aside, the petitioner hearing would be entitled to all the rights and privileges of the license which have been, fair price of license which have been issued. to the petitioner.
obviously,
Obliged.
my lord,
Not writing about the 75. I think this will conclude.
Lordship.
Yes.
Lordship, in this case, Lordship, I have received some instruction not complete because the forwarding part I have not received. But
Only
it
one
seems,
question.
but from here, it seems that terms and conditions were incorporated.
No, not, was it made a part of it?
Yes, yes, because
Whether
here
it-
in the repetition, only two
2000
pages are enclosed.
Huh?
In the repetition of, in the tender, only 2 pages of the tender was annexed, Lordship.
You are reading to which clause?
Lordship, in Assamese, Lordship, sari, ko, ও মাছ মৰা অভিজ্ঞতাৰ প্ৰমাণ পত্ৰ, বাকী যায় মুক্ত প্ৰমাণ 100% মাছমৰীয়া প্ৰমাণ পত্ৰ।
Where? No, not these. I'm not on there. Whether the document, say what you. Very well. Whether the this government or
এইটো নেকি, এইটো কথা কৈছো, এইটো হ'ব নেকি?
whether, you see the government order dated 10/7/2025 say based on the and whereas the Honorable Supreme Court has in its judgment and order dated demand referred to and relied upon the circular dated so and so published in the Assam Gazette, which laid down the procedure and requirement documents for tender-based settlement of ER. And whereas, based on the said judgment, the Honorable Supreme Court had categorically directed that henceforth all tendering authorities must incorporate a specific clause in the notice inviting tender stating that the documents and procedures laid down in the aforesaid circular dated 18/1/2018 shall be mandatorily followed so long as the circular remains in force. A copy of the said circular is also to be enclosed with the NIT. Have you done that?
That circular.
Here also, as per, I do not have the DC's instruction. As per his instruction, I can mean to say page number 19, Lordship. As per, if this instruction, last in the translated copy, for further information, the notification of the government Assam bearing number and tenders have to be submitted by following the terms and conditions enclosed to the tender form as available in the office of the undersigned. So this tender form is terms and conditions is enclosed. That part my friend has may not have enclosed it, and he is saying that this is the enclosed part.
And Mr. Bonik, what is wrong? with
My
you?
my
This is
entire
most
case was not even
important
based
thing.
on this, my lord.
Why haven't you enclosed the entire document?
My only case was,
No, I
Along with,
think
along with that, this format
you
also.
cannot come up with this type of.
no, my case was
No,
on the
your case,
value.
whatever may be. This is not how you file it.
My lordship, we had never challenged it on discount.
I'm not going to, but why haven't you filed the entire document?
My lord,
Where is the tender conditions? The entire tender conditions are not
I
there.
understand what the lordship is taking, but
You
our case
dismiss
was,
it on that ground. Heard Mr. S. Konik, the learned counsel, appearing on behalf of the commissioner. Mr. P. Sharma, the learned counsel, who learned, Mr. P. Sharma appears on behalf, learned standing counsel appears on behalf of Fishery Department. And Mr. S. R. Bulwa, the learned counsel, who appears on behalf of the district administration. This court, by an order dated 16/9/2025, and filed with the learned counsel who appearing on behalf of the respondents as to whether the notice inviting tender is in conformance with the order dated 21/5/2025 passed in special leave to appeal, bracket civil number 18318 of 2024, passed by the Supreme Court, as well as the office order dated 10/7/2025, issued by the Secretary to the Government of Assam Fishery Department. Today, Mr. S.R. Purva has placed before this court the have placed have placed before this court that the circular that the tender notice inviting tender is in consonance with the order passed by the Supreme Court dated 21/5/2025, passed in special leave to appeal, civil number 18318 of the 2024, as well as the office order dated 10/7/2025, issued by the Secretary to the Government of Assam Fishery Department. In that regard, the learned counsel has also placed before this court the terms and conditions of the notice inviting tender dated 22/8/2025, as well as the application
Tender.
which is also the tender form, which is also required to be filed. So taking into account the above, it therefore appears. Now, so this goes further, taking into account the tender document is of the opinion that there has been due compliance. So this court, however, finds it very pertinent to take note of that the petitioner herein have assailed at the notice inviting tender, but for reasons best known, have not enclosed the entire notice inviting tender, as well as the terms which contains the terms and conditions. Under such circumstances, this court is not inclined to entertain the discretionary as well as the equitable jurisdiction conferred upon it under Article 2 to 7 of 2 to 6 of the Constitution in a matter of a present kind, wherein the petitioner herein have failed to enclose the entire tender document. So accordingly, this court does not find any merit in the petition for which the writ petition does not. Accordingly, the writ petition stands dismissed with costs quantified at ₹15,000.
Right.
for admission, item 1 to 7, what are?
The cost part may go because only on the price value.
No, but spoiling the time of judicial test, 15,000. This type of matters you don't file. You should have enclosed them. Or you withdraw and file, it's a different.
The latter. The latter.
If you want to withdraw, you can withdraw with liberty, I can give you.
Lordship.
Fine.
That would withdraw with liberty to refile.
So, is in conformity. The learned counsel appearing on behalf of the petitioner, Mr. S. Bonik, submits that inadvertently the entire tender document could not be filed. So he therefore submits that he may be permitted to withdraw the instant writ petition with the liberty to refile, challenging the terms and conditions of the tender document. Taking into account above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to refile on the same cause of action. The liberty so given is, however, subject to the observations made already herein above.
Obliged.
Item 1 to 7 for admission further.
Is there compliance?
Yes, my lord.
speaking?
Yes, yes. এইখন কোর্টক দি দিয়াচোন।
So, Mr. Nath,
Lodge.
just supposing that whenever there is an application filed related,
Lodge.
because 166(3) remains
My lord.
in the books. So I can't touch. More particularly when I'm taking a 2 to 7, there's no question of me touching.
Lodge.
So whenever that application is filed, taking into account the judgment of the Supreme Court in, what is the name I forgot?
Gohar Mohammed.
Gohar.
Gohar Mohammed.
This would, I feel that the appropriate direction should be that when there is a filing, when there is a belated application filed, and in a case where DAR has not been submitted, DAR, no? The last one is
Last one is that.
has not been submitted, then in that regard, the concerned tribunal shall ask the officer, the investigating officer or the
Aye.
officer in charge of the police station within which the accident happened,
Happened.
as to whether, as regards the non-submission of the DAR, the officer in charge thereupon, in view of that Gohar Mohammed is obligated, as well as now in view of the circular you have issued.
Well, in fact, the instructions have been given to the Commissioner of Police in respect of Guwahati and the SP to the in respect of all the LD district. And my lord, the nodal officers, Lordship has already noted in the affidavit, we have said that they are the nodal officers and the strict instruction has been given to all the nodal officers to implement the decision of the Honorable Apex Court. And if there is some lapse, my lord, they have been instructed to initiate departmental proceeding against the officer concerned. That is
You
been
have
done.
brought in by way of an affidavit.
I have received the instructions, my lord. I have,
I think you bring it by way of an affidavit.
Lordship, I'll bring.
But what I propose is the concerned tribunal
No.
will ask, because you may see, there lot of people, they don't file it, just for example, in Dhemaji. They file it here,
Lordship,
if
it
any
happens.
accident happens.
It
But
happens. It happens.
The officer in charge will be actually the person in Dhemaji,
True, my lord.
will be the investigating officer.
True, my lord.
So, within whose jurisdiction, the officer in charge of which, within which jurisdiction accident happened, the tribunal therein shall ask as to whether the DAR has
The
been
officer. The officer.
and when he informs, yes, the DAR has been submitted or not submitted. If it is not submitted, then he will direct he will be compelled to direct the officer in charge to submit the DAR in that particular, within the jurisdiction of that
Amazing.
that motor accidents
That
tribunal.
tribunal. Lordship.
And by virtue of, again, the Gohar Mohammed, when, as the application has been filed there,
Here.
this particular court shall take away, bring the DAR to his court.
From the other court.
And on the basis of the DAR, as well as the application,
Proceeding will go. Lordship.
I think this appears to be the only way how you connect all dots.
All the dark. Correct. That will be the between the tribunals.
That is the only way. Otherwise, there is a big problem. It means you cannot. Because if I just ask him, as the particular, just for example, if it is filed out here in Guwahati, if I ask the tribunal only that you ask the officer in charge, he cannot ask the officer in charge of within his jurisdiction.
True.
To submit it before him, because that officer in charge cannot submit it before him.
Here.
He has to submit it before the concerned tribunal,
Concerned tribunal. That's true.
within whose jurisdiction the accident happened, because it is his duty also to give the ire, what is the par?
FAR.
Par, ire, as well as the dar.
Yes, my lord.
So the prior to, he has to submit before this particular tribunal,
Correct, correct. The concerned tribunal.
concerned tribunal,
Yes,
in
yes.
whose jurisdiction the accident happens.
That will be. that
This
will
is
be-
for a temporary purpose. Because if these are implemented, then there is no problem. This issue would never arise. Because then by way virtue of government, it will automatically come.
True.
So that is one. And the second way is directing in these cases to the concerned officer to submit the DAR and thereupon to proceed, which I have done in for 2 cases.
Yes, yes,
For 2, 3 cases, I have done that.
yes, yes.
Now, in that case, I can do that also. So these are the 2 options available.
Mal-
But you bring this on record so that I put it in my order that these are being issued.
Not.
So it will have more implications if it is so. And then pass that order that asking, in the meantime, in these cases, you have copies of these, all these 5 petitions.
I have one.
You have an inquiry as to whether the DAR has been submitted.
Well, in the Tejpur case, it is already submitted. Lordship has directed. In the Silchar case also, it is submitted. And in Kolkata, Kolkata is also. That I'll.
Just find it out.
Yes, yes.
And if it is not submitted, if it is submitted, then I'll take it that it has been submitted, then both should be tagged along and proceed.
Malan.
Well, similar pending.
Huh?
Some other petitions of.
Similar. I have filed a similar. That has not been filed. We'll take it. You give the copy, anyways, you give a copy of your petitions to Mr. Dina. He'll inquire as to whether the DAR has been done. This is,
I'll
that
take-
order I'm not passing here,
Yes, yes.
but you give it. I'm only
yes.
tagging these.
Yes, sir.
I have not yet. What? This particular case. Item number 5. Then I have to need to start. But I have not yet started. No, you give it to him as to whether the DAR
I'll-
has been
Lordship,
submitted.
I'll-
He
I'll-
will inquire.
Yes, yes.
Mr. Dina, the learned counsel appearing on behalf of the learned senior government admits that there has been certain instructions issued by the transport department as well as the home department.
This is by the Home Department
by
as well as the
departments of the government,
Assam Police Headquarters.
as well as the transport department of the government of Assam for the purpose of ensuring that the judgment of the Supreme Court in the case of Gohar Mohammed versus Uttar Pradesh State Road Transport Corporation and others reported in 2023 381 is followed. It is abided with in letter and spirit. It is the opinion of this court that these instructions be brought on record by filing the affidavits. And Mr. Dina submits that the same would be done within 2 weeks. Anyway, it is getting close. Means it
Lot-
will be open after the vacation.
Malan. By Wednesday, we'll file.
File shall be filed on or before 17th of October.
Malan.
Let's go further.
Not over.
Inquire with Mr. Dina as to whether the DAR in respect to the cases before this court in the present batch of proceeding have been submitted. He submits that he will make necessary inquiry, and if not, the needful will be done by the concerned authorities by the next day. The counsels appearing on behalf of the petitioners shall serve extra copy of the petition of the revision petitions, in whose cases DAR has not yet been submitted to Mr. D. Nath, the learned senior government advocate, so that he can do the needful. To list this matter again on 4th of November 2025.
Lot.
Interim order faster shall continue.
As submitted, my lord, there some other petitions are also pending, my lord. Those matters, other matters can be taken in this case
You
And
give the number.
we'll,
The learned counsels appearing on behalf of the petitioner submit that there are other petitions which are similarly situated. So other proceedings which are similarly situated are very similar issues have been raised. So he therefore submits that he may be admits that those matters may also be tagged along. So taking into account the above the CRP number, they will give the number. We also tag along with the present batch of presentation and place and listed on photo. And if you have any matters of yours or anybody,
I have.
give those copies to Mr. Aya wherein TAR had not been sub. Okay, both the insurance and the other one, because you see, delay in the insurance is also insurance.
Right.
There's a big problem with the
Interest,
what we call the interest.
interest, but.
Lot.
I will.
It is or not.
Yes. What do you think?
Lord, I have seen the, my lord, the papers, and in my humble submission, my lord, this post of chief administrative officer doesn't come under the purview of subordinate judiciary, my lord. Because it's a creation of the government, pay commission recommended separate pay scale for this employee, my lord.
So you mean to therefore say that they would not come within the ambit of 235 and 236 of the constitution?
Yes. My lord, I can show from the brief itself, my lord. If
Not necessary. I'm asking you for your.
yes,
submission.
it will not come, my lord.
So therefore, the orders which have been passed by the High Court on the administrative side.
In my humble
issuing
submission,
directions
it's
is
not correct.
Absolutely without jurisdiction.
It's not correct, my lord, because the committee's recommendation also,
Committee could not have done.
it's absolutely, my lord, perhaps, my lord, due deliberation was not there because one letter was sent saying that it is within the purview of the subordinate judiciary. That's why equivalence has to be given. Basing on that thing, perhaps, my lord, committee recommended and thereafter Registrar General issued letters. But one document which page 91, I think that is the correct position of law. Annexure 17, page 91. Ultimately, when the entire matter was sent to the judicial department, this was the view of the judicial department, my lord.
So the High Court had no business.
No, my lord. High Court, no business.
This is page 89.
89 is the type copy, my lord. Original, my lord, will find 91.
Even you have better eyes.
Ah.
to see.
My lord, 89 will also do, my lord. 89 will also do.
Huh? No, I got no business.
So perhaps they'll have to
So
approach.
therefore now, they have to satisfy their court in terms with the judgment of the Supreme Court of you, Lalit, and the public. 2018, 19.
My-
You look into the judgment.
My lord, I have some time. I need some time, my lord, to
Why?
explore that aspect.
You knew about this.
My-
Further hearing. You file your affidavit. So the High Court on the administrative side has no business.
Fine, my lord.
File an affidavit because that is required. And what happened? The finance?
We've already filed our affidavit. We've already filed our affidavit.
Well,
Yes, really. 5 minutes.
where is Mr. Arbor Puzat?
He's on Lexington Court number 1.
Okay. And you were there?
No.
So you have not taken that stand? If we deliberated on the last occasion.
Lordship, if your lordship has the affidavit, which is filed by us, we have specifically stated in paragraph 12 and in page number 125, where the pay of the Sheriff Tadar of District and Sessions Judge has been enhanced from 1/4/2023 as per recommendation of the Shetty Commission. And
Where's
other-
the High Court's affidavit?
High Court has not filed. High Court has not filed. Has been filed?
Are they ashamed
No, not.
that they are taking action on the administrative side without having jurisdiction and to say that we don't have the jurisdiction? Things like that. High
No,
Court
in
on the
fact,
administrative
that-
side is doing that.
So far as my understanding goes, my lord, that was a wrong stand. That was not a correct.
High Court has no business.
No business.
No, the affidavit is required because you see,
There has to be clear.
otherwise the High Court is stretching their legs everywhere.
Yes.
So they should stop. They should know where their jurisdiction is. The jurisdiction of the 235 and 236 only limited to the
Subordinate.
district judiciary and the courts subordinate to that.
Correct.
And in view of that Gujarat judgment, the ministerial staff.
Yes.
Otherwise, no.
No.
They have no business with labor court, industrial tribunal or anything. But this is important. Why I'm asking the High Court to file? Because what is happening is the High Court have just put somebody out there as the presiding officer of the labor court. How? You are making a submission, but you know, you have seen the implication.
Presiding officer.
How?
Grade 1 judicial officer.
How?
Is,
So it will be a case of deputation. It cannot be
Same-
by way of, you
same
cannot
cadre.
just,
my lord, he is an officer of same cadre, judicial service grade 1.
no, see the labor court, section 7,
Is all.
industrial tribunal. Act. Because this is not only we are concerned with, because the moment you are saying that ministerial staff, we don't have power, then automatically you don't have power with the presiding officer.
He has for the 3 years. Industrial, oh no, labor.
Industrial Disputes Act. When the auction?
A person shall not be qualified for appointment as presiding officer of a labor court unless he is or has been a judge of a high court, or he has for a period of not less than 3 years been a district judge or an additional district judge, or he has held any judicial office in India for not less than 7 years, or he has been presiding officer of a labor court constituted under any provincial act or state act for not less than 5 years. He is or has been a deputy chief labor commissioner, central or joint commissioner of the state labor department, having a degree in law and at least 7 years experience in the labor department, including 3 years of experience as conciliation officer, provided that no such deputy chief labor commissioner or joint labor commissioner shall be appointed unless he resigns from the service of the central government or state government, as the case may be, before being appointed as presiding officer, or he is an officer of Indian legal service in grade 3 with 3 years of experience in that grade. Look, if this
So it is,
3B,
I can also become a presiding officer, being a high court judge.
yes, 3B says
And I can become the sitting district judge can also become. This is the
no,
eligibility.
one thing that's if I have understood correctly, Miller, if we go by 3B, he has for a period of not less than 3 years been a district judge or an additional district judge.
Yes,
That means a district judge having 3 years of service can be a presiding officer.
but he has to be, he comes under that department, not under the high court.
Now, how can a district judge or an additional district judge can be under the department?
So you may send him on deputation.
No, it is within the same cadre. Deputation will be from one department to another department,
Hmm.
or one cadre to another cadre.
Yeah,
It will be in
because
the
here the
same cadre.
department is different.
Lordship is concerned about the pay, I think, my lord,
No, I'm not concerned with the pay.
because
But the moment you are saying the ministerial staff is out, you see the consequences. The moment you are saying ministerial staff is out, then you are taking 235 and 236 outside the purview.
for the ministerial staff,
How? How do you do it without taking out the kingpin?
No,
The kingpin would be the presiding officer.
because kingpin is, my lord,
How?
3P.
So then obviously then a high court judge tomorrow can also become it.
He is or has been a judge of a high court.
Huh? So then a high court judge can also go and become a labor court judge.
Perhaps this means after retirement or something like. This means-
Because these were made in the year
He-
1964. May have been because there has been no amendment thereafter.
Correct, my lord.
So therefore in 1964 when this was being made,
Check this issue, my lord.
no, this is a very important issue. The moment you are saying that, okay, we are filing an affidavit, very easy. But these people can't be sent on deputation, just transfer.
Your lordship is one way correct that it's sort of a deputation. A grade 1 judicial officer is sent to man the post of presiding officer. It is sort of a deputation. It's sort of a deputation.
Because you see, although he may be drawing up pay as from the judicial department,
Correct.
let us assume that he is manning a pay from the judicial as per the ROP.
ROP.
But the ROP is not his service rule.
No, he'll get pay protection.
He will get pay protection. I'm not on that.
Yes.
But ROP is not rule by where he stands. The rule is his service condition.
Correct.
Read with 232.
Correct.
232 is again a constitutional post, the post of a district judge.
Correct.
So he gets his right on the basis and his service conditions are regulated there.
Regulate.
Now you see, we are not going to appoint anybody else.
Yes.
You are not going to appoint a civil judge. You are appointing a district judge
District.
or an additional district.
Additional district.
So therefore, these are constitutional posts. So that particular person is not of the cadre of the judicial department.
No.
So he, from this particular, being a constitutional
Send there,
post,
you work there.
is being sent to a
Correct.
labor department of the state of Assam. So he becomes an employee of the state of Assam on deputation for the time being. This is how the concept is. This is on the basis of independence of the judiciary,
Yes.
which means silos being maintained. Executive, legislature, judiciary.
Yes.
Therefore, you think from a judicial side, he is exercising a quasi-judicial. This is not a judicial function.
No.
It's more like a quasi-judicial. Therefore, he is not being given those trappings. Certain trappings are not
Traffic, yes.
there. Or by operation of
Some-
the act, certain powers of the civil courts are being endowed upon him. So therefore, he is being given certain powers. Let's for example, a consumer forum.
Yes.
If a consumer forum also has a similar thing. So a person goes out there, he's on deputation.
Yes.
It is not like a deputation. It is
Exactly.
actually a deputation.
Exactly not deputation, but
No, it is actually a deputation because he's actually has to be sent on deputation there.
yes.
Because why you are saying that it is like, it is not, it cannot be like because of the fact there is a reason why it cannot be. Because of the fact that this particular person enjoys a constitutional post. Take the case of a high court judge. Maybe a high court judge at that point of time was getting a lesser salary, so they are also thinking of becoming the presiding
Correct.
judge. over.
Correct.
This high court judge is also a constitutional post.
Yes.
The terms and conditions of his service is regulated by the High Court Judges Act, the 1954.
Yes.
But the fact remains that, like a district judge, the High Court judge also enjoys a constitutional position.
Yes.
Now he goes to the services of the central government or the state government
Yes,
and becomes a member.
what you is correct.
So therefore, it is a pure case of deputation.
Pure case of deputy. Yes.
And the moment if you just file an affidavit thinking that, okay, they don't come, but the person has to also go. Why would in Gujjar, R.J. Gujjar's judgment, the Supreme Court held the ministerial staff is there? Because if you see Article 235 and 236, there is no mention of the ministerial staff.
Yes.
See, it is not there. But it is by way of interpretation, it is being brought in that the ministerial staff also has to. Now here you are saying the ministerial staff is outside, is state government, but not the kingpin. Then why not you bring him within the ambit? Can you have it, the central government official? He is the deputy chief labor commissioner. Also can also come within the judicial department then?
Lord, that will not happen because he
Because
his
High Court,
background is not of a judicial Milord, not of a district judge or additional district judge.
no, I'm
Can
not
be-
saying that.
Cannot be equated.
This particular post, we are concerned with that post.
I have understood, Milord.
That post is a state government employee who may come on deputation. And the basic idea is also from deputation because it doesn't say a retired High Court judge
Correct.
or a retired district judge.
Yes.
It says a person who has been working.
Perhaps if I have understood correctly, Milord, his movement from judicial service to the presiding officer labor court as a deputation is not change his the status as a judicial service member.
No, he loses the trappings of a judicial officer.
Because after some
becomes
time,
an-
he can be brought back also.
Because this is on
He-
deputation.
He always remains a judicial officer.
The-
Even
the-
if he is going there and working there, he remains a judicial officer. So perhaps for that reason, he will not come under the labor department.
No, he will have to come under the labor department because of the fact he is going on deputation.
No, it is not a case of absorption. Had he been absorbed on deputation in the that presiding officer post, then it would have been he would
No,
have,
he is not
would have-
absorbed. He goes only for, but at that point
So
of
his
time,
lien
during
remains here. If he
during
goes
these
to normal-
3 or 4 years, he's sitting out there. It is a case where he is being sent on deputation.
Milord, let us take example of a Milord lower level post. Say for example, an UDA has been LDA has normally Milord deputation is sent in a higher post so that they also go to get some more benefit, pecuniary benefit, Milord. Say for example, LDA has been sent on deputation in the post of UDA in another department by virtue of it, because there are selections also in central government. He went there and it's for 4 years. He retains his lien in the post of LDA in his parent department. So whenever he comes back, he joins the post of
Yes,
LDA.
no, there's
with
no
the monetary
quarrel.
benefit.
There's no quarrel with that.
Now
he
he is absorbed in the post of
and only he loses the lien. No, he's the judicial
the-
officers.
he becomes member of that Milord borrowing department service.
Understood. So his lien always continues out here as a district judge.
Huh.
There's no quarrel with that
So
proposition.
he'll not become a member of the labor department.
No. But he'll be sent on deputation to
Huh?
the labor.
Milord, to that extent, I'm in agreement.
So
with
he
you.
goes out there on deputation.
Yes, that's true.
The moment, otherwise, if you don't have him on deputation, these ministerial
channel
staff
is-
also will come within this. So he also goes, but that is not the practice which is followed. Otherwise, let's take the example of a debt recovery tribunal. They're also the same. He has to be a district judge. You send a district judge? No. If you want to send, you have to send him on deputation.
Yes. Look, to that extent, Milord,
No, but deputation,
being a member of service, of labor department.
No,
He
he,
never.
Mr. Das,
sorry.
I hope you know that I will also be knowing that when a person is sent on deputation, he does not lose the lien.
Yes,
That law, I think I know. I
obviously,
don't know. I didn't
obviously.
need to tell you.
obviously.
That I'm not saying. But when he goes on a deputation.
Yes.
So there cannot be a confusion to that effect. But is it the practice which is followed? It is just taken, okay, today this person is just sent there. Now let's see the motor vehicle.
Like normal transfer order.
Let's see the motor vehicles act.
Like normal transfer order.
Ah.
Has been transferred.
Yes,
Perhaps
that cannot happen.
Perhaps because there is a concept of transfer on deputation also. In central government service, it's there. Recruitment by way of deputation is also there. Transfer by way of deputation is also there. Perhaps they exercise that thing. Maybe, Milord.
Now let us see the motor vehicles act. How it is. See?
Yeah.
Once. Tribunals are constituted under. Yes, claims tribunal. The state government may by notification in the official constitute one or more motor accidents claims tribunal for such area as may be specified in the notification for the purpose of adjudicating. For the purpose. A person shall not be qualified for appointment as a member area unless he is or has been a high court judge. He is a district judge, is qualified, where to area. So here also the same. What
Yes.
is being done out here? A district judge send there. You can send him. He comes within the state government employment. How are you sending him? Tell me.
It has to be by way of transfer on deputation or deputation.
So therefore, when it is a transfer on deputation, it has to be issued by whom? Who is going to issue the appointment order?
Appointment order.
The state government. Can the High Court transfer? Alone?
I'll have to check.
Cannot.
I'll have to check. What I am trying to convey to you, Lordship, is what practice is being
No,
followed here.
practice, and therefore the practice
That's-
needs to be made clear.
Huh.
Now tomorrow, I don't think the High Court would send. The same thing will apply for the DRT. But High Court says that, okay, DRT is central government, we do not.
Hmm.
But anything within the state government, we exercise our muscle power
Muscle power may not be.
or flex our muscles. This is what the High Court is doing.
Muscle power may not be, but
This is how. Tell me otherwise, how on earth the High Court send somebody and appoint him as a motor accidents claims tribunal unless the state government does it.
appointment, my lord. It's not appointment, my lord. Because it's not a
So
substantive appointment.
tell
like-
me clause section 165(3) of the Motor Vehicles Act, section 7 of the Industrial Tribunal Act. It says about appointment only.
Maybe, my lord,
Then who is going to appoint? The central government or the state government can appoint. It is under them. The appointment happens. Can the High Court
But the
unilaterally?
service condition of that officer, that doesn't get changed.
Therefore, the question is, when you are bringing him, you may give him the pay protection. You may give him the pay protection, whatever he is getting out there, but we are bringing him into the State Department. Tomorrow, you make him the Chief Secretary, a district judge. You feel like. But can you, tomorrow, the High Court says, that, okay, we appoint him as the Chief Secretary.
That cannot happen.
This is the same.
That's a different thing.
No, this is the same because he is not exercising judicial powers. You have to understand that.
I understand, my lord.
A
Partial
power which
judicial
is
power.
being exercised because Motor Vehicles, the Motor Vehicles Act, all these things, these are quasi-judicial.
Partial
powers.
judicial.
So you're denuding him. So therefore, it has to be an appointment by the state. So you file your affidavit
Yes,
on this because you cannot just say that, okay, the High
Yeah.
Court is wrong on that.
no. One aspect I'd like to
High Court is
clarify.
wrong. There's no quarrel. High Court is
In
wrong.
this, my lord,
High
so
Court
far
is
as
wrong.
CEO
But
is
then
concerned,
also,
it's-
the moment you are saying, see the implication. The implications are
Milord,
far and wide.
Milord, deputation of a presiding officer or a Milord, judicial officer as presiding officer in the labor court is totally different from the issues involved here in Milord.
No,
No, Milord, it's different.
no, the moment, I have to say that the High Court has no business under 235.
The
with
moment we conceive,
respect to the ministerial,
No.
the moment I'm saying that, it
the
takes
moment we
away
conceive
35 and
no,
236.
no, Milord, with all due respect, the moment we conceive it to be a sending on deputation, the conclusion is that he doesn't become a member of state service. He remains as judicial service. So this person, the petitioner herein was the post against which he was appointed was created by the government. He was appointed by the government. The pay commission, Milord, provides for the pay, fixes the pay of that particular employee, Milord.
Who appoints these persons? The district judge? Who appoints the district judge?
The government. It's by the
State government. Because I remember this very well. Once there was one judicial officer, he had to be transferred from some MACT to somewhere as a district judge. He could not be immediately done. Because the judicial officer had good relation with the state and the state was not releasing him. Because the borrowing department also has to release.
yes.
Because that was the practice which was followed. And this was not long back. This must have been 2025, 2004, 5. Mr. Das must be knowing that officer 4, 5. He was not being released because he was very close with the government.
But
Good.
that cannot be, Milord. That cannot be.
Why?
If parent deputation says, law with regard to deputation says that you are there for a fixed period, 3 year, 4 year, maximum 5 year. So after that,
No.
if your parent department
no,
asks,
no.
you have to come.
Not 4, 5 years. He was there only for 1 year.
No, he was there, but the law is that if you are sent for a fixed term, after expiry of that term, you have to come back. And the borrowing department has to release him. They are bound to
The
release.
fixed term. If you see the Guru Swami's judgment, it says there has to be, this has to be done by mutual discussions and the High Court cannot on its own say once it has been sent on deputation. If you see those judgments of Guru Swami and all, you therefore find that all these are constitution bench judgments whereby the Supreme Court says, the constitution bench says, and these are matters from Guwahati, Assam. This person was sent on deputation as some secretary out here for the JR department or LR department or earlier LR. He was sent on deputation because he becomes a state government. Now you send make the LR, the district judge. How do you do it?
LR is also now judicial officer goes, Milord, grade 1 judicial officer.
How? How do you appoint?
By way of transfer.
Transfer where? That is not your post.
No.
So how do you do it?
He is only manning that post.
No. He cannot man that, but there has to be an appointment by them. Something the government has to, you are asking the government.
That missing link, Milord, I'll just place, Milord. What is that
there's
missing
a
link?
missing
What is
link
the
out there.
procedure?
No, you are sending him.
Yes.
And that was the case where he was sent on a LR. And the government says we are not releasing him. And the Supreme Court says that there has to be something being done, but High Court cannot exercise 235 in that and ask.
Bring back.
Like that. Because fixed period. And these are judgments of Constitution bench.
Yes.
Not
I'm-
followed
I'm
by
so
your High
sorry.
Court, it is a different thing. Can't help it.
I'm sorry, Milord, I haven't gone through that. But I'll
Go through that.
definitely, yes, Milord.
That was the specific case in there, where it's a case from Assam, 1971. So it's a case from Assam, how it. I referred to that deputation judgment of, huh?
I was in this Guru Swami's case.
Ah,
I think that Arunachal Pradesh case, the
Ah.
power of the High Court 235,
Ah.
say
yeah.
vis-a-vis LR case is
You cannot.
All the judgments, constitutional bench judgments.
You cannot take away. Therefore, the LR also, you just cannot say, okay, I'm sending him to as LR. No. You have to say that the government has to be, the government has to appoint him.
There may be a process of requesting
Hmm.
by the government to the High Court
Yeah.
that, look, here we have this particular post,
Ah.
send some judicial officer here to man the post or to be appointed in the post. That missing link, I'll just
This is
clarify.
how it happened. Because you cannot bring, because these are he's after all constitutional post.
Yes, yes, no, there is
Post
no doubt
of
about
a district judge.
Yes, yes, yes.
So how do you take him out and make him just a state government employee?
No, that cannot be.
So you have to do it. You are giving him an administrative work. You're making the LR an administrative officer. This is how it is.
I understand, Lordship's point. I'll clarify.
Now, these High Court rules. High Court rules permits bringing them.
Yes,
What a High Court rules
Yes.
permits bringing them,
yes,
although not on deputation. Because this is being permitted because High Court is also exercising 235
yes.
and 219 powers. So this is how it is being brought.
Yes,
Although not satisfactory, but it's,
correct.
so you file an affidavit
Yes, ma'am.
because you see the consequences of that.
Yes.
And Mr. R. Bhupade is
Because-
nowhere to be. Okay, none appears for the finance department on call. Mr. H.K. Das appearing on behalf of the Guwahati High Court submits the taking into account the issue which have been, the question which have been formulated by this court by the order dated 14/8/2025. The Guwahati High Court would like to bring on record the affidavit to list this matter on 13th of November 2025. In the meantime, the affidavit be filed on or before 6th of November, giving advance copy to Mr. P.D. Nair, the counsel appearing on behalf of the petitioner. Liberty given to the petitioner to file reply.
Keep clear.
Much.
So on the last occasion, your lordship has directed them to file an affidavit. The affidavit has not been filed.
Yes, Mr. Das, how are you appointing these people as people?
On the last occasion, there was deliberation in this issue. And my learned brother, Mr.
You have a
Gogoi, said that office memorandum.
memorandum now,
One notification is there, Lordship,
whereby it says that all people have to be outsourced.
outsourced and no
Outsourced.
permanent post shall be created. Lord. That is there, Lord. But so far as the present petitioner is concerned, Lordship, here she is praying for minimum pay scale in terms of that offender's judgment, Lord. And what I have noticed, Lordship, here her appointment was in the year 2011.
When does cutoff date is 2006?
Or judgment was in the year 2017, and there the time period was 10 years prior. So at least 2007 law, but the department allowed from 2005, that pre-FRBM law. So those who were appointed prior to 2005, they have been given minimum pay scale law. That is the position, right? So far as the present petitioner is concerned, Lordship, her appointment was of the year 2011.
Now, the question of paying you the basic minimum fair amount of remuneration or the scale of pay attached to the post for regularization and for regularization. Regularization cannot happen that there is no post. Can be created. That is the policy. Unless you come up with a case bringing it within the ambit of Dharam Singh. You can bring your case within Dharam Singh. Very well. Consider. You've seen the judge.
Lordship, in Jagdish Singh's case also, Lordship, there is a direction, Lordship.
Jagdish Singh is a
Jagdish Singh,
different thing.
Lordship, to
Jagdish Singh is, see, Jagdish Singh says, give him the scale which is also given to another officer or another person who is working in the same rank. Now, here the question of giving for another rank does not arise taking into account that there is no post of sweeper. So Jagdish Singh cannot be brought in. Jagdish Singh, what does Jagdish Singh say?
Lordship,
It says that these people who are working, similar work is being performed, which is being performed by the people in the regular cadre. They should be given the minimum of the scale of pay, which is being given to those persons. That's it. But you have to have a corresponding rank. Now, in the establishment, there is no corresponding rank by which a person can be appointed on a permanent basis as a sweeper. So a sweeper cannot, therefore Jagdish Singh cannot apply. But the fact remains, however, that these people have employed you, kept you in service for the last 14 years, 13 years, 15 years you are going on. But they are not creating the job which are also required to be done. You have to challenge the very policy of the government. Say, look here, you cannot do this. Taking into account that Dharam Singh, improve your case by filing an affidavit, additional affidavit. Isn't it?
But
you have that judgment, Dharam Singh.
Dharam Singh, I don't have that. Something.
Yes, what is the citation of Dharam Singh? Dharam Singh was judgment 2025 HCC of
recent
SC 1695 or 101295.
2020.
This is a recent judgment in the month of September, following 3 judgments, all authored by Justice Vikram Nath. So you develop your case. There is a very fine distinction being taken out from Uma Devi. Uma Devi says that the High Court cannot, the 226, direct regularization.
Regularization part, Lordship, I have to keep, Lordship.
No, High Court cannot.
High Court.
Then the next question comes. There is another judgment called State of J&K versus District Bar Association Bandipara, wherein it further goes ahead to say that the High Court not only cannot direct, but the High Court cannot also direct for formation of a scheme. Formation of a scheme also. But in Dharam Singh, Jago, and Sirpal, these are the 3 judgments wherein a different aspect has been brought. If you are keeping a person in employment and taking into account that the job is required, non-creation of a post is justified.
That is exactly my case.
It is there. So you develop your case on that.
Dharam Singh citation is, my lord, 2025 SCC online SC 1735.
Because there,
Completely new dimension.
Sirpal.
Sripal is also there, my lord. Sripal is 2025 SCC online SC 221.
So look into these 2 judgments. Develop your arguments
Yes,
on that. Then we will see. But you need to have a prayer also, huh?
In
We
that
should-
event, perhaps, my lord, subject to what my learned senior says, that office memorandum, perhaps that will be a hurdle in between, perhaps.
That is not the only hurdle now. Even Jaggu has created a hurdle. If Lordship reads Jaggu Lordship, paragraph 21 specific, the appointment has to be legal. That was not a case for the illegal appointment. And when you say legal, there should have been at least one advertisement, written test, interview, everything. If it is illegal, then Jaggu do not apply. That is the case of paragraph 21, Jaggu itself distinguishes. Petition employees like the petitioners and those petitioners. It's there.
Look into that. And if necessary, you challenge. This is how you, because this is a very interesting aspect. The matter came up before the High Court. The High Court says that in view of Uma Devi, we cannot direct it. Matter went to the division bench, the division bench upheld. Court says the High Court was wrong in not doing so, taking into account that the High Court did not look into it. That these posts were required to be created. And if these posts were created, you cannot allow a person to work for all these years. And knowing it very well that these posts are necessary. You say that, okay, you want to outsource it very well. But the fact remains out there, but these posts have to be given. They are a welfare state. I hope the High Court, the state of Assam is a welfare state. Or the High Court is also a welfare, comes under welfare.
Sweeper, my lord.
Unless both the High Court and the state says that the directive principles which this court cannot direct enforce also is not applicable to the High Court as well as the state.
Trend is changing, my lord. The trend is changing.
Nothing has changed.
No, no,
Look,
trend is
okay,
changing.
My friend will read all these judgment, answer is there only, Lord.
Oh, obviously, my lord, state will never see the petitioner side. That is nothing, not a new phenomenon. But what I'm saying is that trend is changing. I'm saying that lordships mentioned the directive principles of state policy vis-a-vis the decisions that are coming from the Honorable Apex Court. There is some similarity in that, my lord. At one point of time, there has to be.
One point of time, one has to also understand at one point of time there were mass illegal appointments. Mass illegal appointments. For that, there was a requirement of curbing. And therefore, and the High Court were passing right, left, and center
Exactly.
directive regularization.
That's
And
why
the
Mali
states were-
became.
had to create jobs. And you have to think about that time in 1990 or 2000, because Uma Devi came in 2006, and this was Uma Devi 3. Prior to that, you have even this Piara Singh.
Yeah.
Piara Singh, paragraph 47, 1. It also gives some way. But Uma Devi makes it very clear to the effect that you look here, this is not done. You cannot keep on appointing because the state is the person who is create the job. It is the finances of the state. But things improve. Now we say that our state is the India is the third or fourth.
Trillion.
third or
Yes.
fourth, or going to be the
Developing
fourth,
nation.
having the fourth GDP or something. So now you cannot say that the people out here can be kept on this 9,000 rupees for long.
In
This
fact,
is the trend.
in fact, in Uma Devi also the whole idea of Honorable Apex Court was that stop this illegal appointment, don't make any, and whoever was there irregular, regularize them as a one-time measure. If we go by the para 53. Now, even after Uma Devi also, Lord, I have came across cases wherein after 2006 also, my lord, the casual appointment is there. So
fact,
how
we-
to deal?
We read paragraph 53 categorically say
The whole idea
that
was to
those
stop
persons who
here.
have been working for the last 10 years should be regularized as a one-time measure.
Yes.
And the state should not engage anybody
In,
except by way of regular.
in fact, the duty, it
But
was
the
a
state
duty.
continued.
Lordship, my appointment was done because during the establishment of the CGM building, Lordship. That was a necessity. There was no other stuff, Lordship. And that is why, Lordship, the CGM Gosaigaon is also.
There's no quarrel with that fact
Lordship.
that a sweeper is an essential part of every establishment. There's no quarrel. They may, the government may say that, okay, we outsource these people out. But that job is an essential part. Like a judge of a high court, the sweeper of the high court is also an essential part. Without that, what are the people going to suffer out there? And nothing will be clean out here. This is essential. It's a part and parcel of the institute. So therefore, you develop your case in there. Like the file an additional affidavit, or if you want to challenge this type of memorandum, challenge it. But you have to
Lordship, I will go through the judgment, Lordship.
go through it. Pursuant to the order passed on 14/8/2025, Mr. Denied, the learned standing counsel of the finance department has placed before this court an office memorandum dated 30/3/2022. 12. And relies upon clause 8, which stipulates that sweeping and cleaning services are to be outsourced and post of the sweepers shall not be filled up in any department on any ground, including compassionate grounds, except in government hospitals, as per the stand of the government already submitted before the High Court and the judgment issued thereon in WPC number 10447 of the 2003, based on their stand. The copy of the said office memorandum, a copy of the said office memorandum has also been furnished to Mr. S.K. Das, the learned counsel, to submit that if necessary, he would challenge the same law.
And it is prior to my Lordship date of, my appointment is prior to the issuance of the. I was appointed in 2011.
The said office memorandum is kept on record. Lists the matter again on 13th of November 2025. Liberty given to the petitioner to file additional papers. Bring that you were appointed in 2011 prior to this. Secondly, bring those. We'll see. You may not get, but there might be a case for direction for creation.
Right.
In fact, after Uma Devi, in my understanding, Milord, there was an obligation cast upon the state, whether state government or central government, to regularize all this person and make it an end. That was how I have understood, Milord. Milord, in this matter, Milord, I have received the affidavit, vetted and signed, Milord,
This is matter
today.
of-
I'm filing, Milord, during the.
Five post of peon. 5 post of peon. We
Hold on.
advertisement, ultimately we are selected, but there is a judgment passed by this court. Three particular person who was promoted to the post of LDA, that somebody was, it was put to challenge for the High Court. And this court has set aside their promotion order and they were reverted back to the position of peon. But my service was kept in evidence, thereafter terminated. Your Lordship has said there is no question of interim order, we'll hear in the entire matter. In the meantime, they have to file an affidavit.
Milord,
Now,
I
the
have,
question which I remember out here is some persons were promoted to the post of UDA or something. That promotion was wrong and I have interfered
Correct.
with it. Resultantly, they were reverted
Reverted
back
back.
as LDA.
As peon.
LDA.
They were reverted back as a peon.
Then
From-
to the promotion to LDA.
LD.
Yes, right.
they have come back to the post
Grade
of
four.
MP of.
Grade 4, yes.
Now, those against that existing resultant vacancy which arose in view of these persons being promoted, these people were, you were recruited.
Yes.
Now, what has happened? In view of that judgment, your appointment was kept in abeyance.
Yes, correct.
Now, these people have already been promoted again.
Yes, right.
Now, you want that you should be brought in.
Yes, but there is
Now, they want to go for a fresh selection.
fair, correct. That's the position. Yes.
Milord, yes, I have, Milord, received the affidavit, Milord, signed and vetted, Milord. I'm filing it during the course of the day, Milord. There is, Milord, it is not only for the reason that your lordship's interference with the promotion order, their selection was cancelled. There were other reasons also, Milord. There was inherent flaw in the select list. So those I have mentioned in my affidavit, Milord. So
But if you mention that, then obviously you will have to reply.
Yes, my
They have not supplied the copy.
I'm filing it, Milord. I
It's the
just
state
received.
as the
Milord.
learned Standing Council of the Guwahati High Court submits that the affidavit is going to be filed by providing advance copy to the council for petitioner. This court inquired with Mr. H.K. Das as to whether any selection has been carried out pursuant to some indictment. Any selection has been carried out which is which has been challenged in the instant proceedings. No.
No, Milord. Promoted posts were filled up by subsequent.
No.
Oh, no,
Uh,
after, no.
they have-
Grade 4, no.
He submits that nothing has been done in that regard, taking into account the pendency of the proceedings. So this matter again on 13th of November 2005. In the meantime, the petitioners are given the liberty to file their reply by 3rd of November.
Right.
I'm filing it during the course of the day. Milord.
Much. 13 November.
13th November.
That's item 12.
Yes,
and Now, this matter pertains to the
13 November,
the
okay.
post of head assistant in the CGM establishment, Marjorie. Last order was there, my lord. The selected private respondent, my lord, he does not have the requisite qualification under Rule 6. He was not even eligible to have been considered for. Should have reflected in the last order.
Look, in this matter, I have received the instructions. I have prepared the affidavit also. Lordship will permit me some time to file the affidavit. I have entered APS for respondent 8, Lordship. I have already filed Ukalami.
We have not filed the affidavit.
Lordship,
Consider the intent prayer.
Lordship,
Yes.
My lord,
on 16, Lordship, we have filed Ukalama. We have entered APS 16.
Okay. If the government of the High Court has not filed the affidavit.
Lordship,
we
fix the
consider
matter
the
next week,
intent.
Lordship. Lordship may fix the matter next week.
No. Today. Next week, no. Yes,
My-
what is your case?
My lord, I was promoted to the post of UDA, my lord, on 8/7/2013, page 24, my lord.
8.
8/7/2013, 8th of July 2013, my lord. I was promoted to the post of UDA,
Post of,
Upper Division Assistant, my lord.
this is to the post of head assistant.
Head assistant. Head assistant.
Head
It's
assistant
in the
is
CGM system.
CGM.
CGM system.
Then
Thereafter, my lord, I was promoted to supervisory assistant, my lord, on 20th of March 2023.
6-3.
20/03/2023.
This is as per 6-3.
6/3.
Okay, then.
My lord, there was a advertisement, my lord, from the CGM's establishment, Majuli, my
then?
lord. My lord, at page 41.
One. Yes.
Last photo page with me was. This is for the post of head assistant, one post, my lord, and eligibility is candidate having 10 years experience in the service as upper division assistant continuously, including supervisory assistant as on 1/3/2024. It's unreserved, one post, my lord.
My lord, the promotion order,
And then
my lord. Thereafter, my lord, there was a notification of 30th of April 2024, my lord, at page 45, publishing a list of 6 eligible candidates, wherein the private respondent's name appears, my lord, at page 45.
what is the name of the private respondent?
Bohonto Payung,
Bhakanto Payung.
my lord,
And he worked in the CGM Majuli.
my lord.
Then
My lord, the final result, my lord, there was a select list and
and how
there
many
was a,
years of service he had? As
my lord,
UTA or supervisory?
as UDA, my lord, his promotion order, I have annexed, my lord, at page 39. He was promoted on 31st of July, 2019.
4 years, 5 years, 6
5
years.
years, 5 years, as on 2020. Page 39, my lord. The second last paragraph, my lord, Bohonto Payon, lower division assistant in the office of the subdivisional magistrate Majuli, is hereby promoted to the post of upper division assistant and posted so.
And what about the other?
Others, my lord,
You are Manoj Putin Dwara.
no, my lord, I'm Pankaj Kumar Das. I've annexed the mark sheet, my lord, at page
You
46,
got 31, the Payung got 38.
my lord.
Hello?
I was the second there, but
You have 10 years.
my lord, yes, my lord.
And what about the other two?
Other two, my lord, I'm not very sure of, my lord, but
But he doesn't have.
he does not have. The selected candidate does.
But you had.
I have.
Heard Mr. P denied the learning council appearing on behalf of Mr. H.K. Das, who appears on behalf of the Guwahati High Court, and Mr. K. Goenka, who appears on behalf of A. The petitioner herein is agreed by the appointment of the respondent number 8 as the head assistant in the establishment of the Chief Judicial Magistrate Majuli, on the ground that the respondent number 8 did not have the requisite 10 years of service, which is one of the conditions for eligibility in terms with Rule 6.1 of the Assam Chief Judicial Magistrate Establishment Ministerial Service Rules 1987, where as well as the advertisement dated
7/4/2020.
7/3/2024. The Learned Council appearing on behalf of the petitioner has drawn the attention to the order dated 31/7/2019, whereby the respondent number 8 was promoted to the post of upper division assistant and submitted as on the first day na,
My lord.
of the year on which the advertisement of the year
What's that? March
as on 1st of March 2024. 24, na?
24.
24. The respondent number 8 did not have the qualification. The Learned Council further submitted that Rule 17, na, relaxation.
Yes.
The Rule 17 of the rules rules could not have been applied in the facts of the instant case, taking into account that when there were other eligible candidates, the question of relaxation cannot be made. So this court further finds it relevant that on 22/8/2025, this court made, while issuing notice, made it very clear that the interim order would be considered today. Made it very clear that as there was no instructions on that day, the interim order was not passed. However, making it clear, however, it was clearly stated that if the affidavit is not filed by the official respondents on or before today, this court shall consider the interim prayer. So the affidavit, however, have not yet been filed. And nothing has been brought on record to show as to why the respondent number 8 was given a preferential treatment in spite of the fact that the respondent number 8 did not have the eligibility. And there were already eligible candidates who had the experience. Considering the above, it is therefore the opinion of the court that the selection of the respondent number 8 as the head assistant prima facie appears to be contrary to Rule 6(1), 6(1), no?
One.
of the Rule Chief Judicial Magistrate Rules. Rules of 19. So accordingly, this court therefore stays the appointment order dated
My lord, 10/1/2025, page 47.
with 40
7.
appointment order dated
Notification.
10/1/2025 issued by the district and session judge Majuli till the disposal of the requisition.
Deeply obliged.
List the matter again with the counsels appearing on behalf of the respondent seeks for an opportunity to file the reply. So list this matter when
Affidavit, after 2 weeks, my lord.
on 10th of October, vacation.
After vacation, my lord.
So you are saying 2 weeks,
I'm sorry. I'm sorry.
20th of November 2025.
Fine.
The affidavit be filed on or before 24th of October 2025. Liberty given to the petitioner to file reply thereafter on or before 12th of November.
Deeply obliged.
Perhaps my affidavit will be a bit of formality only because I have received the Xerox copy of the records, but I wanted to see the original records. What actually was there. But my lord, apparently he was not eligible.
And more particularly, the fact is on that day, you see, if you have eligible person, you can.
Yes.
And in my other judgment, I have made a very clear distinction in respect to the district district and session judges, and both are head assistants. The district and session judges is inside the department,
Instead,
whereas is
CGM,
anybody else.
yes.
But otherwise, that's one of the it is senior. Otherwise, senior.
Senior has no
Yes.
business.
Other because his appointment initial appointment.
One question may come, my lord, I don't know whether if a person is of superior merit, subject to, my lord, what my learned senior says, my lord, whether this can be, my lord, condoned, this qualifying service. If something has come out on records, no, this person is brilliant, absolutely, my lord, whether in that event it can be, my lord, condoned. That may be a question of, my lord, argument, but apparently what against the pleaded
superior
case.
merit is a difference of 7 marks only, not the 50.
That is also an issue. Yes, Lordship is
And
correct.
7 marks be the question that he is so superior enough. Otherwise,
Be an appropriate case, my lord, but
I would have
not in-
understood he has got 50 out of 50. And this person got only 20.
31.
So, and
My
that-
lord,
that
my lord.
20.
Mm.
Then obviously,
My-
this court may say that this person under no circumstances have, or we can set aside this appointment. Why should we set aside? Here is the case with 7. And for your chief judicial magistrate or the district judges, for them, I think they are anticipating the draft rules. And as such, they think that these rules are nothing. The papers to be thrown in the dustbin. This is how you follow.
some gaps, I think there.
That day I was thinking about that case as regards the qualification can it be. I am of the opinion you addressed me on that day that as the
Kobita Bora,
secretary,
Kobita Bora.
how can qualification be a part of judging the in your minimum merit. How can qualification be? If you bring qualification within the ambit, you're not tinkering with the rules.
I'll address, my lord. I have formulated something, my lord.
That is a very thing. I think the moment you bring in, you have all other thing is okay. But if you have the qualification as the criteria for judging the minimum merit, and the word is minimum.
Yes.
Word is minimum. The problem arises because of if it says that okay, merit will be looked into, you need the minimum eligibility to go there. So can you bring in qualification when the rules does not say so? Meaning, are you not giving emphasis on the qualification? Think of that.
Lordship has given me homework, my lord. I'm working on it. I'll
Yes,
try
okay.
to.
It's not that you are working. I'm also thinking
No,
about
that we know, my lord, your effort
it
put
was
in by your lordships, my lord.
these are things like his matter out there. I thought about it because it will, the moment you file an affidavit in that matter and saying that we have no business, it will have far-reaching consequences.
No.
I hold it.
I cannot say I don't have any business, my lord.
No,
I cannot say.
With regards to ministerial stuff, you have no business.
Huh.
It will have far-reaching consequences. I hold it. They have no business. Tomorrow, the question will come, what about these? You see, it has to be no business in the touchstone of 235, 36.
Huh,
And
huh.
if you hold it that you
No,
have
no business cannot be like blanket, my lord.
and
No.
if you have business,
Huh.
if you have business, then why not the petitioner is there?
Okay, in this case, one surprising fact, Lordship, respondent 8 was promoted as a LDA temporarily in the year 1995. Against the same, a petition was filed. That was dismissed in the not for non-prosecution. That was his LDA was confirmed in the 2012. Because all was thinking that the petition is pending. So
You file your affidavit.
after 17 years,
No, you file your affidavit, and if that is the consideration being taken, we'll consider it. Don't worry. I am always open. I have not taken it. I take it only for the purpose because last time I stayed, I didn't stay it because I told him that you file your affidavit. Because I thought that you would come up
I
with that
tried
we have-
my best, my lord. I tried my best, but it came late. Then honorable
Yeah.
waiting judge was not there, so
you
that's
come
why.
up with that you were already promoted and then subsequently confirmed. Then obviously direct recruit can be brought in. And thereby your date of promotion would be taken, confirmation will be, the date of appointment will be taken as the date of confirmation. Isn't
Yes.
it? Relate that. So that you can very well argue. Once you file your affidavit, I'm always open. I keep on, day I put a question to them and put it in my order, and the next day, that day, I put a question in favor of Mr. Espora and pass an order to the effect, and thereafter the next day I fixed it. Then the other side showed me something. Mr. Bora had nothing further to say but to get a dismissal. Don't worry. Open.
Much obliged.
Deeply obliged.
May I please your lordship? Mr. S. Dotto is on his leg.
Who is Azota?
Shishir Dotto, Senior Counsel Shishir Dotto.
Where is he?
He's in court number 19. Kindly pass over the matter.
Lordship, before starting Lordship, I am in a precarious position, Lordship. Your Lordship may take up the Employees Provident Fund and Miscellaneous Provision Act. Lordship. Lordship may take up the Employees Provident Fund and Miscellaneous Provision Act for immediate Lordship. The bearing.
Why?
Lordship, I think appeal is provided in the matter.
Appeal?
Lordship. I checked to my understanding, Lordship.
You don't have a case. You see, we can very well apply the judgment of the Supreme Court in AIR 1971, page 33, wherein it says that if a matter has been admitted and pending for the last decade, this court should decide on merits.
Lordship.
Why should we go into the
What happened that this petition was, this is the second round of litigation, Lordship. I think it was hurriedly filed that point in time because earlier our review application was not considered by the authority on that ground, we came before this honorable court, and this honorable court allowed for reconsideration of our review. And while applying the 7A provision, Lordship, they have turned down our prayer. So in against the 7A order, Lordship, appeal lies, Lordship, as per 7 capital I, Lordship. And they have not taken the plea, but as I have checked, I'm just informing this honorable court, Lordship. Because CGIT is there, is the Central Government Industrial Tribunal is the appropriate authority for filing the appeal.
Appeal lies to where?
Central Government Industrial Tribunal.
No, they have not filed the appeal and prepared review. So, my lord, you,
Lordship, 7 capital I, Lordship. 7 capital I.
Yes, appeal to tribunal. Any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the provisions of section 3 or 4, section 3 or subsection 4 of section 1 or section 3 or section 1 of section 7A or section 7B, except an order of rejecting an application for review referred to in subsection 5 or section 7C or section 14B may prepare an appeal to the tribunal against such.
Lordship.
Now, what is your case? Your review has been rejected.
No, Lordship, what happened, Lordship? Lordship may peruse, Lordship, 7 capital A 4, Lordship. 7 capital A 4, Lordship.
An order under subsection is passed against an employee ex parte. He may within 3 months from the date of publication of such order apply to the officer for setting aside such order. And if he satisfies the officer that the alternative was not served or that he was rejected by an court hearing when the inquiry was held, officers shall make an order setting aside the hearing. The date. So it is like a vacating the ex parte.
Lordship, initially what happened, it was first ex parte, Lordship, to approach the authority for setting aside the ex parte order. That was not considered. So we approached this honorable court. The honorable court by order directed the authority to consider our application. So we filed application again, Lordship. After hearing everything, Lordship, order under section 7A was passed. 7A, Lordship, 7A proceeding, determination, 7A, capital A.
7-1
on merits.
On merit, Lordship. Against that, Lordship, as my understanding is, Lordship, appeal may lie, Lordship. It is impugn order, your Lordship will find at page 79, Lordship.
So your case is the tribunal initially passed the tribunal.
Authority.
The authority initially passed an order under 7A.
7A ex parte. Lordship.
Ex parte. You filed an application under 7A. This application was rejected.
Not considered, Lordship. Not taken into consideration. Against that, we approached the normal.
Was not taken into consideration. For which you came before this court. This court directed the authority to again
consider Lordship.
The 7A4 application.
And
then the authority allowed your application. But decided on thereupon, wait and decided on
merit.
Yes, ma'am.
So you now say that you want to go.
No, Lordship, I have
on
seen appeal, Lordship. I think Lordship 7I, it was Lordship, the petitioner approached the honorable court. That was my understanding was wrong, Lordship. Because they also filed their affidavit only 1 month back. So record was like this only.
Yes, what do you say?
But the time period to file appeal that has gone.
Don't worry, that we can take care.
My lord. If my lord gives liberty, my lord, they can avail those.
I grant them 30 days to file them.
My lord.
Lordship.
I'm not condoning the
My lord.
saying that I grant him 30 days because you an appeal to be filed before whom?
Lordship, Central Government Industrial Tribunal, Lordship.
Because here the Limitation Act does not apply.
My lord.
So I have to give them the time to file it. why should I send it to for filing an appeal? You think that you file an appeal is another thing.
No.
Why should should say it? Because I have to answer it, or write it out here that why it is required. that you have
What
to
happened,
be
Lordship?
sent.
I've gone through the writ petition, Lordship. I've seen, Lordship, lots of factual matters are there, Lordship. Lots of disputed question is there, whether the office was there or not, what is their finding, what is our stand, Lordship. That, Lordship, I think, Lordship, evidence will be required, Lordship.
This is holding you 18.
Lordship, clubbing,
That
Lordship.
18 things.
Lordship, no, clubbing, Lordship. That's the issue, Lordship.
No, this is how many people are there. That is why
Rick-
whether
Rick-
you will
Rick-
come within
Rick-
the
Rick-
arbitration.
20,
Yes.
20 required, Lordship.
Yes, Manoj. 4 institutions, they are clubbed
They've clubbed.
together to come to a conclusion that more than 25 members are there in the institution.
So now they say that
They're against that, my lord. They say that clubbing is not permissible under the act.
they say.
The clubbing.
That is why this, because, my lord, we came to a finding that this act would be applicable. This finding was under, my lord, 7A1. Not that institution was already, my lord, the act was applicable to the institution. First, my lord, the authorities have reached a finding with regard, because there was a dispute regarding applicability of this act to an establishment. So, my lord, an inquiry report.
So it will come under, it's a termination under 7A, 1A and B also. You must have determined that. no?
Yes, thereafter we determined also, yes. So their ground for challenging it by way of writ petition was that, my lord, clubbing is not permissible under the act. Clubbing of the various institutions is not permissible under the act. Therefore, the decision of the authority in coming to a conclusion that this institution EPF Act is applicable, that is wrong. That was the ground they have come before the writ court. Now they are saying they want to prefer an appeal because certain factual determination was wrongly held by the adjudicating authority.
What do you?
Well, if they want to prefer appeal, my lord can grant them
have lots
liberty.
of time.
Sorry, Lordship.
I've got the- You want to decide on merit, I can do it. You want to decide on, send it out there. But you-
My lord, so far as merit is concerned, my lord, there are judgments of the Supreme Court. Clubbing is permissible. I have taken out the recent judgment, my lord. Clubbing of institution is permissible.
But there are only cases on clubbing.
I'm not disputing the
in the
clubbing,
writ
Lordship.
petition.
Only, Lordship.
No, they are on that only, my lord. They are on the applicability of the act. Because we have come to a conclusion by, my lord, clubbing 2-3 my lord, of the establishments, their establishment, to come to a finding that the members are more than 25. That is the required number of members to which the act would be applicable. So their written objection was, my lord, on this point only, that the act is not applicable. That finding has already been reached.
Okay, let me come back at two.
My lord.
Both of you think about, then I'll pass it. Either of you want the judgment,
Go to
I'll
this one,
give it to you. You want the judgment on maintainability, I'll give judgment on incertainability, I'll give. But the only problem which I'm finding is, how do I take care of the judgment of the Supreme Court that keeping the matter pending for the last 1 decade and say that, look here, go and file an appeal.
That is their, Lordship. Only what I'll be submitting.
That is a big
Lordship. What,
think about it.
Lordship.
In this matter, my lord, the affidavit that has been filed by the Administrative Reforms Department, they only say that they are entitled, but there's nothing beyond that they have said. So I have spoken to my learned friend. If your lordship allows me some time, I would like to, because the telephonic conversation that I had with the AR department, they are saying that the state government drivers are getting. So we can follow the same pattern. Your
But
lordship,
as per rule 23, no? If the state government drivers are getting, they also have to get.
exactly. On that, there's no quarrel. In fact, I have already spoken to them. They'll get it. Your lordship will fix it after the vacation. I'll try to bring it by way of an affidavit, and that should make the things easier.
Is a program called, what's called Rule 29, no?
Rule 29.
But Mr. I. Chaudhary, the learned advocate general, Arunachal Pradesh, who submits that that government of Arunachal Pradesh would like to bring on record and as to whether the state or the drivers employed in services of the government of Arunachal Pradesh are being provided the benefits of MSW full form to this matter again on 20 November.
Yes.
20th November.
20.
November, the affidavit will be filed by 17th of
Right.
Yes, Mr. Council.
Lordship, may I pray this matter will be taken as next item. Mr.
Which
Gupta
one?
is on legs. Item 14, Lordship.
What am I taking now? 14 only.
Lordship, Mr. Gupta is on legs, my lord, is another.
I've heard him.
Lordship.
Lordship, I pray that matter is allowed to go, I may be allowed to go for appeal, Lordship. Because lots of factual things are there.
Mr. Doctor, what do you say?
I'm for the bank. Now, for going to appeal, my lord, possibly in the read court, there are so many factual aspects are there. Whether your lordship can go to that aspect also. In that view, the matter possible. Only one thing, my lord, unless the delay is, if your lordship give
Delay, I
some
will
concession
condone
to
it.
them.
Delay, I will condone it. Don't worry. I'll give them 30 days.
In that case, it is better to send it back for.
That is okay, but how if I have kept the matter pending for the last 10 years?
Yes, yes, that
does
is
it
one
look
aspect.
Nice for the High Court on the issues involved, unless it becomes impossible for the High Court to decide to send him not to entertain the writ.
Yes, yes, that is also, my lord,
And
lordship.
if it is at the request of the petitioner, is it the case where the petitioner had bona fidely approached this court? Then can he be given any benefit?
My lord, they came here way back in 2016. Possibly, my lord, that relevant time appellate forum was at Delhi. Now, it was not available here. Possibly on that view of the matter, easily, my lord, they came before this honorable court. Now, the appellate forum is here itself.
But can the court exercise jurisdiction under 226 on the basis of convenience?
No, no, not at all, man.
So how do I take that account and hold it that that is a proper forum? Tomorrow, the various lawyers will take up that issue.
Yes, yes.
And instead of going to NCLAT, will be very well very well file here with petition.
No, that of course, your lordship will not do.
That is not permissible.
Not permissible.
Lordship, only lordship, that is their lordship. Only what happened in this case, 2 reports of the enforcement officers are there. Lordship may be required to place those 2 reports.
Employees provision.
Two orders passed by the authority, 2 reports, lordship, by the same officers. That's lordship may require a test by way of evidence, which evidence may be required because lots of documents they have relied upon. The documents are not before this honorable court, you know. To club my establishment, they have placed various documents, lordship, and they have stated various statements also. So that requires some cross-examination, lordship, and proof is required, lordship. If a lordship produces lordship page 44, page 44, lordship, is the first order, lordship. And lordship, if the matter is, if the petition is allowed to go for an appeal, lordship, the provident fund will not lose, lordship, as because date is fixed. They fix the date 1/1/2005, lordship. If I lose before the appellate authority, then interest, lordship, will accrue, lordship. That part is their, lordship.
Art so the learned counsel appearing on behalf of the petitioner. Mr. H. Gupta, who appears on behalf of the respondent. Petitioner, Mr. So who appears on behalf of the respondent number
4, my lord.
124. Mr. S. Dr. the learned senior counsel appears for the respondent number
6.
6. No. 6. The petitioners herein have approached this court challenging the order dated
Page 79, lordship, order dated
29
4/2016, lordship.
29 2
2016, lordship.
2016 passed by the Regional Provident Fund Commissioner as well as the certificate case number 3/2008-9 issued thereupon. It is relevant to take note of that the petitioner herein is petitioner number 1 herein is an unregistered firm,
Lordship.
partnership firm,
Partial company.
and the petitioner number 2 and 3 are partners. They are engaged in the business of manufacture and sale of confectionery items. The case of the petitioner herein is that the provisions of the Employee Provident Fund and Miscellaneous Provisions Act 1952 cannot be made applicable in so far as the petitioner number 1 and the action on the part, and as such, the impugned order. As such, the order dated 29/2/2016 passed by the Regional Provident Fund Commissioner. Number 1 have been put to challenge. The materials on record further show that the respondent number 2 herein passed an ex parte order on 1/8/2007 by making an adjudication in terms with section 7 capital A bracket 1 for the Act of 1952 of the Act of 1952. The petitioner against whom the order was passed being aggrieved against whom the order was passed, order dated 1/8/2007 was passed. Having been passed, now against whom the order dated 1/8/2007 was passed ex parte, filed an application in terms with section 7 capital A bracket 4 of the Act of 1952. The said application, however, was not taken into consideration. And as such, the petitioner approached this court by filing a writ petition being WPC number 309/10, challenging the inaction on the part of the respondent number 2 not to consider the application filed by the petitioner under section 7A bracket 4 of the Act of 1952. This court, by an order dated 4/9/2014, directed the Regional Provident Fund Commissioner, that is the respondent number 2, to reconsider the matter in the light of the application filed by the petitioner under section 7A bracket 4 of the Act of 1952, and preferably within a period of 3 months. The respondent number 2 thereupon accepted the said application and decided the issue on merits by passing the impugned order dated
29/2/16.
29/2/2016, thereby adjudicating within the ambit of section 7 capital A bracket 1 of the Act of 1952. It appears that, being aggrieved, the petitioner thereupon approached this court by filing a writ petition, filing the present writ petition. This court, by an order dated 25/4/2016, issued notice and further state the impugned order dated 29/2/2016. This court, while taking up the matter, this court further heard the learned counsels appearing on behalf of the parties. The learned counsel appearing on behalf of the petitioner submits that the findings of facts arrived at in the impugned order dated 29/2/2016 are are arrived at without taking into consideration the actual facts, the facts of the case. Per contra, Mr. H. Gupta, the learned counsel appearing on behalf of the respondent numbers 1 to 4 submits that clubbing the various establishments of the respondent number of the petitioner, number 1, is permissible in terms with the Act of 1952. This court, having heard the learned counsels appearing, finds it pertinent to observe that there would be a requirement for adjudication on the facts as to whether upon clubbing of the establishments, which is otherwise permissible in terms of the Act of 1952, the petitioner, number 1, has employed the number of persons to come within the ambit of the Act of 1952. This court at this stage finds it pertinent to take note of the provisions of section 7A7.
I, Lordship. For appeal is 7I, capital I.
7 capital I. Which of the Act of 1952, which provides an appellate forum against any order passed under section 7A capital 1 of the Act of 1952. It is the further opinion of this court that factual disputes, that this opinion of this court, that the adjudication which can be done in the present proceedings is limited, taking into account that this court would be only exercising a certiorari jurisdiction. However, when there is an appellate forum, the appellate forum can, when there is an appellate forum, the same forum can go into deal with the facts. Also, when the issue involved at present is on the question of pure question of adjudication of facts. Considering the above, this court therefore is of the opinion that the instant writ petition, though have been filed in the year 2016 and pending till date, is required to be, ought not to be entertained. More so when the learned counsel for the petitioner had also submitted that the petitioners would be prejudiced if an opportunity is not given to the petitioners to avail the remedy under section 7I of the Act of 1952. Accordingly, this court therefore disposes of the therefore not inclined to entertain the instant writ petition for which the writ petition stands dismissed. Next. This court, however, grants the liberty to the petitioners to approach the appellate forum as mandated in clause section 7I of the Act of 1952. And taking into account that the petitioner have been diligently pursuing the present litigation, this court grants 30 days time to the petitioners to prepare the appeal. So it is further observed that if the petitioner prepare the appeal within a period of 30 days from today, the appellate authority shall not insist on the question of limitation, but rather decide this dispute on merits.
Item 13 fixed at 2 p.m.
Excuse the lordship.
What is this?
This is against an award. Your lordship has heard that matter.
I have not heard anything.
My lord, this is a matter where the charges were held to be established in the labor code. The charges were without inquiry, the workman was dismissed, terminated from service, and they adduced evidence before the labor court. And my lord, the documents which were relied by the management and the labor court in support of the charge were not proved by the maker of those documents.
By the
Person who had issued that document. So
it's required.
My lord,
Is it required?
my lord, it is required.
Why?
Because the one who was examined is not the maker of the document. So it has to be proved. The contents of the document has to be proved by the one who has made the document. Because lordship,
What is your basis of that submission?
my lord, I rely on a judgment which says I'm relying
Name?
Life Insurance Corporation of India and others versus Rampal Singh Bishan, 2010, 4 SSC 491.
Labor court matter?
It is not a labor court matter
Labor court matter, you show me.
because,
Because the Evidence Act strictly doesn't apply.
my lord, here, no, it is a matter relating to a departmental proceeding
So what?
in a suit.
So what? Not a suit. Show me where a judgment has been delivered by a Supreme Court saying that the Evidence Act shall apply. You are relying on section 67 of the Indian Evidence Act.
Yes.
How is it possible to do this? Yeah.
I'm relying, my lord.
Some other council judge may be more kind enough than to do this matter before me.
Other ways also, then if for the time being, if we assume that it is not required, then the documents by the same person which I have relied was not taken into account.
Huh?
Now, management relies on certain documents issued by the owner of a petrol pump. And the same owner has written letter to the management saying that I am not involved. Labor court takes into account that document but not relies on my document.
So on the ground of perversity.
Number one. Number two, my lord, if your lordship takes up the writ petition, what is
Oh, this is the case. Now I remember. You have you stole the petrol,
no, I have not stolen, my lord.
diesel.
I have not, my lord.
Which
I have
one?
not.
No, you have taken those cars out there,
No,
put
no.
it in their names, and then they have taken the oil, and thereafter you are not paying out there. When the bill went to them, the management came out and said that, look here, where is the amount? Why should we pay? They said that this particular person has come out here, filled up his gas and all the oil out there, and now in the name of the government and so, and then you are taking out the oil and selling it outside. This is the
No,
way
no,
I
no, it
can
is not
later on
a,
that
it is not a
particular
case
person-
where,
That person concerned has said that this has happened. Now, later on, that very person concerned who have issued that particular document, he says that I have never issued such documents.
no, he says that I was not involved.
It was somebody else. So my lord, when,
So why didn't you bring him as a witness?
because the same person, the management relied on his letter, I rely on the letter issued by him. So if X is good for the management, X is also, it should be good for the workman also. If, because your lordship will have a look at the charge sheet, show cause, which your lordship will find at page 16.
Page
16. No inquiry was held.
Not necessary. This type of, when you have falsification, all the
My lord, it is a
misinformation,
case of termination of
this
service,
case,
my lord.
This you should be terminated, right, left and center. Yes, come on.
My lord will see, this is in reference to the pending bills of fuels issued against 108 dumper service. He was the driver of 108 ambulance service. Where from this dumper service came, I do not know. We have received a notice from Oil India, Indian Oil Corporation. It is not Indian Oil Corporation, regarding payment of an outstanding amount of so and so lifted by you for 108 service from April 2004. This is a serious lapse on your part and it is not acceptable.
You are hereby advised to provide a written explanation in this regard within 48 hours.
It was issued on 23/3/2021.
Then what
On the next day, on the same day, I was transferred.
This is in reference with the disciplinary proceedings against you, as few allegations have been reported against you. To investigate further, it has been decided by the management to relocate your service from Tipsagar to Kasumari.
So I was transferred.
Therefore, advised to report at Kasumari.
I was transferred. Now, this is the letter which is the foundation of the allegation.
So Louis Fuel Service. 1 year, the outstanding is so and so 1,57,000. Fuel has been lifted by your program manager Saurabh Datta. What is your name?
I am Joyanto Datta.
And Joyanto Datta.
Who had given them constant reminders, we have given them.
Constant, we had to make the payment, but after some time we not get through. So yeah. So sir, as you see that the considerable time has been passed. This is given by Manoj Poddar.
Now, lordship will
Then again
come to page 20.
for payment of AR to Sanjoy Jha. Who is he?
My lord,
Sanjoy Jha?
Sanjoy Jha is the vice president of the organization. Now, this page 20 letter is important.
The matter of a very long time without payment. And they are writing every time.
Then, my lord, page 20.
This is in reference to the pending bills against the dumper. Management has found that you involved in fueling dumper by using company's name. It is against company's protocol and you have violated the same by involving in illegal activity. Then
Lordship may come to page 20.
where are your documents?
Page 20, it is exhibit 5. It was exhibited. Page 20, annexure 6.
I've looked into these.
Now, may I read the entire?
Oh, this is given by Manoj Poddar.
Yes. Earlier also, all the letters were issued by Manoj Poddar. Now, your lordship, this letter is very important. Mr. So-and-so and Mr. So-and-so had come and told me that.
So had come and told me that if you want to get your pending bills of Iman to be released, then you have to just write a letter, and also told me that the names of program manager and so. Therefore, I have written a letter as direct. Sir, our bills have been pending for so many years and my major concern is to get my money back. I personally do not stay in the depot premises all the time. I do not know the 108 people personally. Therefore, when Mandip Lahon and Bhaskar Gogoi identified through their photograph, mentioned the program manager's name, I wrote them accordingly. Moreover, I know Joyanto Datta by face and not by name, so I mentioned his name in the letter. Huh? I know Joyanto Datta by face and not by name, so I mentioned the name in the letter. So I want to clarify that Joyanto Datta was not involved in the case. Then,
So, these documents were examined and there is another document, my lord. It is exhibit 6, which is not, my lord, It is in the record, exhibit number 6. It is in the record where it is another letter written by Manoj Poddar. Would like to clarify that due to some mistake, we sent letter dated so-and-so to you, 108, and Jayanto Datto are not involved in this matter. It is a matter of Saurav Datto of 108 dumper service. In our books of accounts, Saurav Datto's name got omitted and only 108 dumper service remained.
But tell me, the moment you are relying on exhibit D, are you relying on exhibit D, which is annexus 6?
Exhibit D is relied by the management.
Are you relying on annexus C?
Yes.
6.
Yes, my lord.
What does annexus 6 say?
That I am not involved.
Apart from that?
It says that somebody else has.
No. Says that he had issued those 2 letters.
My lord.
Exhibit annexus 6 also say that those 2 letters were issued by Manoj Lohan or whatever you mean.
No, Manoj Poddar.
Manoj Poddar had issued.
Yes.
So therefore, by this document when you are bringing it, are you not therefore admitting that those 2 documents were actually issued by Manoj Poddar?
Yes.
So are you not admitting the authenticity of those 2 documents? Maybe the contents may not be wrong. Contents may be wrong. I'm not, Mr. Chakraborty, contents will be wrong. There's no quarrel. You may very well say you deny the contents of those 2 documents. But the fact that the existence of those 2 documents are being admitted by you because of Annexus 6.
Now,
because Annexus 6 categorically mentions.
I have written, but it is an explanation regarding writing that letter on a.
I wrote that letter on a mistaken thing, on the basis of some person coming up and telling us if you put the names of the program managers, then you'll get the money. So are you therefore not admitting with that document that those 2 documents were issued by Manoj Poddar?
Now the question comes, if those 2 letters can be relied solely to hold me guilty, why this letter will not be taken into account to show my innocence?
Because you have to prove that this document, because of the fact this is your main person. The evidence of this is the main person who should have given the evidence. The reason is, by this document you duly admit those 2 documents have been issued by Manoj Poddar.
Other way, my lord, if this document is not treated as a part of exhibit, now if it is discarded, for a moment we agree that this document is not accepted and it is discarded. So this document, by this document, the admission of those documents will also go. So
it won't go, because this is a document you cannot say no. You cannot say that this document should not be, I don't trust this document. And later on coming in, when you are producing this document.
My lord, what I understand, a document has to be read entirely. It cannot be, a portion cannot be picked up to suit the management, and the portion which goes against them should not be taken into account. So what is the material before the...
No, I'm not saying on that the contents is right or wrong of this. But when you are relying on Annexus 6, can you say that Manoj Poddar did not issue those 2 documents?
I am relying exhibit 6 or 5 to contend that Manoj Poddar had written that letter under a mistaken belief.
Understood. Everything. But the fact that those 2 letters were written by Manoj Poddar is not in doubt. Maybe the contents you don't accept. But those 2 documents have been written is not in doubt.
Now, how the Labour Court has dealt with this part of the evidence? Labour Court has totally discarded it. On what basis? Presuming that this is a manufactured document and issued at my instance. On what basis labor code, can a court of law presume something and record a finding?
Presumption is always there.
My lord.
If you tomorrow, just for example, let us say, you are held with drugs.
Something else will be better, my lord.
Presumption is always there that you know these are drugs by virtue of section 54 of the NDPS Act.
Even if it turns out to be.
And therefore that presumption has to be rebutted by you.
Even if that turns out to be something else in the FSL report, it will be always presumed to be a drug. Even if the FSL report says, no, it is not drug, it was just a talcum powder.
So that who is going to prove? If the FSL report comes.
My lord,
if
to the limited knowledge I have in criminal jurisprudence, the burden of proof is always with the prosecution.
No. In NDPS matter, the burden, initial burden is upon the prosecution to show that we have looked into these. This is the FSL report. This is what it is. We have found the drugs out here. That initial burden, if it is discharged, it is for you to prove
that it is not drugs. Even if the FSL report says that it is not drug talcum powder, but
no, Mr. Chakraborty, you are not understanding. Initial burden is for the prosecution to prove that, look here, that this is the FSL report. We have caught him. This is the Caesar list. These are initial burden. The ones that is being discharged, the initial burden, the presumption is upon you to prove that that is not a drug there.
No,
the FSL report is wrong.
Here is
the
a case.
FSL, these particular findings were not done properly. You have to put those questions out there.
But my lord, here it is a case where I have been terminated on a ground of misconduct.
Absolutely. Right.
Now, the law is well settled, my lord. If it is a misconduct and the award of punishment is termination, the charge has to be proved. And while proving the charge, I should be given the opportunity to cross-examine the witnesses and the documents and the maker of those documents.
So
because
that management witness you did not cross-examine?
yes, because the management witness, the one who has examined, this Manoj Poddar was never examined.
I'm not on that. But have you cross-examined the management?
Yes, I have cross-examined the management
Let us
witness.
see your cross-examination. What did you say? Cross-examination, Dipankar Das. Being the senior manager, I have come to depose A. I do not remember the exact date when Jointer joined the services under so-and-so. We received a complaint exhibit 7 against Jointer. Thereupon, as per norms, he was served with the show cause notice and he was transferred to the area. Internal department was conducted against him, but no formal domestic inquiry. It is not a fact we did not consider exhibit 8 submitted by Jointer Datta. He was terminated from service by the exhibit E. Except the show cause reply of A, other documents were not received from him. We have not paid him the gratuity and other dues. What remains? You have not even questioned on this very document.
No, my lord.
Well, no, that is the main thing. You should
Now,
have
this
cross-examined
document to
Now,
have
let us see your cross. What do you say? I was working as an associate of so-and-so. Initially, I was posted at so-and-so. Till my last transfer, I've been working I was transferred to Golaghat in the month of so-and-so. There was only 110. We used to fill fuel in the vehicle from Louis Fuel Service at so-and-so. The fuel was taken on credit. The operation executive used to collect the fuel bill from the petrol pump and send the same to the head office for payment. At the time of refill of the fuel in 108 vehicle, the petrol pump used to obtain our signature on the slip maintained by him. I know Manoj Poddar, who is the owner of the Louis Fuel Service. After my termination from service management, I came to know that the proprietor owner of the year sent a letter dated demand to the vice president. The letter was related to pending bills against 10. So far, I know management did not run any 108 dumper service. It is not a fact that I know that the fact of the state letter since before my termination from service. I was terminated from service in the month of May 2021. I came to know about the said letter when I was served with the show-cause notice dated 23/3/2021. The letter also referred to the name of Saurabh Datta, who was the program. I did not lodge any FIR against the fuel service. I joined in the services of the management of so and so on demand. I have submitted the copy of my show cause reply when I have submitted before the management. I have not submitted any certificate regarding exhibit 3 by whom and from where it was obtained. It is not a fact that exhibit 3 is a fabricated document for the purpose of this case. I have not summoned the person who has issued exhibit 4. Exhibit 4 were fabricated for the purpose. I have not filed any review petition against my termination. It is not a fact that I, in collusion with Sora, illegally procured fuel from Iman for refueling 108. Gaurav Datta resigned from his service.
My lord, my submission before your lordship is, if the documents exhibited by the management witness is accepted, then why the documents exhibited by the workmen will not be taken into account? Because the same principle will follow.
Not follow. Division bench may help you. I am not going to help you.
And the entire action was on the basis of an internal investigation. That investigation was also not made public, at least not made known to the workmen.
Exhibit 5 and 6 were with whom?
Exhibit 5 and 6 were exhibited by the workman in his evidence.
But are these proved in original? Obviously, it was not to you. Did you ask document?
It is there in the record, my lord, exhibit 5 and 6.
Understood. It was therefore not signed by the court, na? It was not admitted in evidence, these two documents.
But lordship will see the order award at the last.
They
page of the-
mention it, but this is otherwise not admitted in evidence.
Exhibit 5, maybe my lord,
You gave all photocopies. All photo. Yes, madam, tell me.
Your Lordship, I would like to, as you have already gone through the cross examinations of both the management company as well as Jayanta Kumar Datta, the petitioner. The
What
o-
did you do after getting that letter of 10/4/2021?
We held an internal departmental inquiry, Your Lordship, and no domestic inquiry was held. Thereafter, we terminated him after
Internal inquiry after getting 10/4/2021. You issued the show cause notice on,
23,
3/21.
23/3/2021.
you issued him a show
After
cause
5
notice
months.
on 23/3/2021.
Yes, Your Lordship.
Okay. 23/3/2021, then he gave that letter. Did you get the letter of 10/4/2021 or not? Which is exhibit 5
Yes, Your Lordship.
from Manoj Poddar or not?
10, 10 foot. So that document has been exhibited by them, by the workman's side.
Has that document not been given to you?
Your Lordship, here I only have with me, the documents I have is only the evidence of the workman, evidence and affidavit of the workman that has been exhibited there.
All these, you see, that document is addressed to you. You have received the other two documents which were the complaints. One is of October 2020 and the next one is another date. This is another relevant date.
10/4.
24/3/2021. 24/3/2021 is after you issued the show cause notice. But before that, before your termination on 15/6/2021, have you received the communication of 10/4/2021 and made a domestic and any inquiry, internal inquiry?
Yes, Your Lordship, we made an internal domestic and internal departmental inquiry. And that was also laid down before the labor court. However, no domestic inquiry was held. On the last date of hearing before this honorable
You
court,
had the inquiry with whom? Did you have an inquiry with Manoj Poddar? On the basis of that document of 10/4/2021?
Lordship, I have no relevant document as of now to show it to the honorable court, whether Manoj Poddar was involved in the,
Because you see, why I'm saying so. Did he submit a reply to the show cause?
that is what he is contending, Your Lordship, and there's a one-pager reply just saying that he was not involved, but we do not have that document with us. It was issued on 24/3.
24/3 reply. It is
No, 20.
exhibit 3.
Hmm.
Post that.
Exhibit 3? What exhibit? Exhibit 3 is different. That is your document. Because they have exhibited ABCD.
Yes.
You have exhibited as exhibit 3.
3. It is the
This
reply.
is the reply. With regards, I beg to inform you that I'm
In written reply, I joined the transfer post.
not this, Your Lordship. Your Lordship, page 6 of the affidavit in of evidence of the work hand.
You have not submitted a reply to the so-called. See, Mr. Chakraborty, there's a big collapse on the part of whoever was conducting the matter.
It was conducted by a union official. Union.
Very poorly done. You see, what has happened is it appears from the records is October 2010, a letter was issued.
20.
2024 or 20.
20. 15, 10, 20.
Letter was issued. Then you are issued a
show cause.
They make some inquiry or something, they issue a show cause on
23/3/21.
23/3/2021. Then they receive a reminder from Lloyd on 24/3/2021. You don't submit a reply.
On the same day, I was transferred.
Whatever may be, you don't submit a reply. So
though the evidence says that there's some reply was filed, I don't have that reply with.
You also don't say in your evidence also that you filed a reply.
But something is stated at paragraph 5. The management has issued show cause letter dated so and so by giving a reference to so and so, so and so, so and so. Subsequently, the said Loiso in the letter dated 24.
You say that you have given a reply on 24/3/2021.
My lord.
With regard, I'd like to inform you that I got a show cause notice where I'm not involved, so I have attached the letter given by Iman, clearing certificate that I was not involved.
So maybe he is
Now, you
relying.
see, now, interestingly, see this letter. This is Exhibit 3.
My lord.
Where is the letter that he is not involved? That letter comes into existence on 10/4/2021.
No, if your lordship takes up the other letter 24/3 at page number 19.
24/3, what does it
That
say?
is letter dated 24/3 written by Manoj Poddar to Sanjay Jha. This last line. So we can say that Mr. Jayanto Kumar Datta is not involved in this case.
Where?
Second paragraph, it starts from third line. So we can say that Jayanto Kumar Datta is not involved in this case. That is a letter dated 24/3.
So this is the basis on which you give your reply.
Perhaps, my lord, because I was not there, but I don't have that letter.
Yes, madam.
Even, my lord, this.
Your
You are
lordship,
relying on this Exhibit D.
your lordship, if you see the exhibit D, the first para, your lordship, it is written, today we received a letter from Jayanto Kumar Datta stating that he had been lifting fuel from a depot for his own 108 vehicle. Now, firstly, he has no his own 108 vehicle. It is only management's vehicle, your lordship. He cannot lift it for his own vehicle. Secondly, he has mentioned the names of Jatin Burgohai, Saurav Datta, Saurav Bora, and Kukil Buragohai were involved in this matter. So we can say that Jayanto Kumar Datta is not involved in this matter. If your lordship, he is himself not involved, how does he know the exact people who are involved in illegal lifting? Secondly, if he is relying on this letter, as already pointed out by my learned counsel, that a document cannot be read partly, it has to be read as a whole. So in this, they have also written that he was lifting fuel from his depot for his own 108 vehicle. So 108 vehicle is only the management's vehicle. He does not own, and he's only a driver of the vehicle, your lordship.
You have a 108 vehicle.
No. No, I'm the driver. So
Therefore, we have received a letter from Jayanta Kumar Devkar stating that he has been lifting fuel from our depot for his own 108 vehicle.
that is why, my lord, what I understand, my lord, this Manoj Poddar was the person who ought to have been examined by the management to hold me guilty. Because if a lordship takes my cross-examination, one thing comes, my lord, the 108 service vehicle was also taking fuel on credit. And the clarificatory letter says that there is, by mistake, he has given all these things.
But anyways, whatever may be, this Manoj Poddar informs you after issuance of the show cause notice the next day that look here, Jayanta Kumar Datta is not involved.
Your Lord,
How do you then come to a finding on 15/6/2021 that he was involved? Where is the link thereafter? Because 15/6/2021 is the termination.
termination letter.
Let us forget about 10/4/2021. It appears that 10/4/2021 was came into existence only as he said. The petitioner comes to know about 10/4/2021 only when he received the communication dated 19/5/2022, which was addressed to him by Manoj Poddar.
Madam.
That is another aspect. Let us not take into account because these happen subsequent to his termination. But what did you do on the basis of this? Because you see, the labor court have duly relied on Exhibit D also. Exhibit D, forget about his evidence. Exhibit D categorically mentions one thing, that Jayanta Kumar Datta was not involved. So what is your evidence that he was involved?
Your Lordship, if
Because you did not have a departmental proceeding. So therefore, disciplinary proceeding. So therefore, you have to prove that he was involved.
Your Lordship, during the course of proceeding, before the labor court, when there was cross-examination of Jayanta Kumar Datta, the second page, Your Lordship, we have disputed the document, that is the Exhibit 4.
Exhibit?
Exhibit 4, Your Lordship.
Madam, let us not take into account 10/4/2021. That is Exhibit 4.
No, Your Lordship.
What is Exhibit 4?
Exhibit 4 is the letter of 19/5/2022.
Let us therefore take it, we don't take into account 19/5/2022, 10/4/2021, let us not take. But you have terminated
Yes, sir.
without a disciplinary proceeding. So therefore, there is no evidence in that regard. What is your evidence in respect to taking into account Exhibit D? Exhibit D says that Jayanta Kumar Datta was not, so we can say that Jayanta Kumar Datta was not involved. How do you, what evidence you brought that Jayanta Kumar Datta was involved after Exhibit D?
Your
That is what we require.
Your Lordship, that letter,
Let
24.
us see your evidence. Read. Management so and so, 21, so cause notice. Fair and for fair investigation on the matter of so and so, that on the next day the show cause notice was issued to the worker so and so, wrote another letter mentioning that they received a letter that he was Iman and have mentioned so and so were involved. After due investigation, dissatisfied with the reply of the workman, so the reply has been given, and owner of the Lloydberg had terminated so and so. So you have to show something. Why there has been a dissatisfaction? Show me. Otherwise, you don't have a case. He has a case.
Your Lordship, during the cross-examination, if some document is not disputed, then it is impliedly admitted, Your Lordship.
Madam, you have exhibited Exhibit D. Exhibit D letter is admitted by you?
Lordship.
In the evidence of your witness, he categorically mentions that after the issuance of the show cause notice, you receive a letter from Louis
Hmm.
on 24/3/2021. But as well as the petitioner's reply. But you are not you are dissatisfied, for which you dismissed him. Why you are dissatisfied? That is the question. Because let us not go into 10-4. Let us not go into 19/5/2022. These documents, okay. He has given photocopies. We are not bothered. Let us not go. But the fact remains that during his cross-examination, he has not admitted that he has done anything. As well as also the fact remains that what is your dissatisfaction has also not been mentioned. Why? When this particular person concerned categorically mentioned in Exhibit D that Jayanta Kumar Datta was not important. Wouldn't this come within the ambit of perversity for this court to exercise the writ in the nature of social? What do you say?
And my lord, lordship will see how exhibit D was examined by the labor court. Labor court says exhibit D is a procured letter. On what basis the labor court is saying that exhibit D? Exhibit D.
No, Exhibit D, he cannot because they also did not say so.
And the
Your
finding.
evidence also did not say that Exhibit D is a procured letter. So the labor court is wrong.
But then your lordship.
But I think, madam, the best option would be for setting it aside and remanding it.
Your lordship, one thing,
Get this Manoj Poddar, either of you, clarify. Either that. Otherwise, we have to set aside. Exhibit D is bad. Is damaging for you. Let us not go into his evidence.
And if a lordship takes up the termination letter or the evidence, they are giving whole thrust on an internal investigation. And that
internal investigation, you can do it very well. But what did you arrive at in the internal investigation has to be stated in your evidence. Very poorly done, you also. You were the person.
no, your lordship, someone else was the counsel. I was
Very
not.
sad. Both counsels bad before the labor court. And Mr. Chakraborty has also not come up with although he's considered to be a labor expert, he has not come up, he is going into section 67.
problem is, my lord, in the labor court, this workman was represented by a person who is a union leader. And that union leader, my lord, has taken up the role of a lawyer in most of the cases where the workmen are being represented by him.
Okay, let me come back and allow his petition.
Your lordship, I have one submission to make.
What submission?
Your lordship, if during the cross-examination when the management was cross-examined, they have not disputed any document.
Not necessary. We are not.
But we have disputed the document. We have also asked whether you call the.
Oh, madam, we will not take note of exhibit 1, 2, 3, 4, 5, 6, which he has submitted. We are not taking it. The fact that you have received the communication from Manoj Poddar in October 2020 is admitted.
Yes, sir.
The fact that you have issued a show cause on 22/3/2021 is admitted. The fact that on 24/3/2021, you have received a letter from Louis is also admitted because that is exhibit D. The fact that you have received a reply from him is also admitted. Because you see paragraph number 10,
Evidence, yes, Your Lordship.
paragraph number 10 of the evidence on affidavit, he categorically said is admitted. The fact that you have received 24/3/2021 is also admitted. But there is nothing on record why you did not trust the second letter, where you clarified what means you have to connect somehow. There's a big gap. Can't help it. That state of affairs. So what relief can be granted?
My submission before Lordship is as per the law, when a charge is leveled against a workman, then the charge needs to be proved. Now, from the evidence, it appears that the management failed to establish the charge.
But what do you say about loss of confidence?
My lord, that loss of confidence will come only when the charge is established. It is my humble submission before Lordship. The loss of confidence will come if someone is held to be guilty on the basis of the materials placed before either in an inquiry or Lordship is well aware that even if no inquiry is held, the labor court, the management can or the employer can very well establish the charge before the labor court. So in that process, the labor court becomes the inquiry officer and takes upon itself the duties of.
Madam, we'll have it on another day. You look into the question of loss of confidence.
Yes, Your Lordship.
Because then it will become can it be a case of reinstatement or can it be a case of compensation?
Because, my lord, loss of confidence, with all respect, my lord, loss of confidence will come only when the allegation is held to be proved. It is only then.
No.
My lord, if I
Show
am,
me.
my lord,
I come back in 5 minutes. Show
my
me.
lord, if I am accused of committing theft in a bank or somewhere else, so long the accusation of theft is not established, how can I be held to be someone over whom the employer has lost his confidence? Because you are alleging something and it is the burden on you to prove that I have committed theft. Here it is a case where the management could
No, Mr. Chakravarti, that is not the law. Loss of confidence is sometimes, even if it is not proved, the court may not direct reinstatement as the person have lost the confidence. That is the concept of loss of self-confidence, not on the basis of that. Otherwise, too, there is no problem. What you are submitting, his charge is not proved, then he has to be reinstated. Why is the question of loss of confidence concept? The loss of confidence comes that when the employer have lost the confidence, he should not be imposed upon to keep the employee. But can there be a question of...
My lord, that is why I am submitting, if someone has lost the confidence, there has to be certain cause and materials.
No.
Of that opinion, my lord.
I think this needs to be tested. So we do one thing, we dismiss your petition right away, go to the division bench, the division bench may help you out on this loss of confidence. Don't come up with that type of submission. Loss of confidence is when it is not proved. The question is, should then also the court direct reinstate? More particularly, this loss of confidence is on the question, not on any other aspect. Misconduct, somebody hitting somebody, somebody doing something is not a question of loss of confidence. The loss of confidence is directly proportionate to or related to misappropriation. Here is a person who has been asked to run the 108 services. He has misappropriated. This is what the company thinks. Now, but during the proceedings, they fail to prove it. So therefore, the question is, the labor court's order has to be set aside. But is it the case that I should reinstate? Or is it a case that it can be done with compensation? Look into that
Yes, Your Lordship.
better. Not on the basis of what he says. Don't trust that. When? When?
I leave it to your lordship, my lord.
You are the person who wants to show on loss of confidence something else which I've never heard of. 3:30.
My lord,
3:30?
today,
Obviously.
on the question of loss of confidence.
Yeah.
In that case, lordship will take up this matter tomorrow.
No, not tomorrow. Tomorrow other matters are there, na? Or should I be only sitting for Mr. Suman Chakraborty on Saturday? Only. I'm always there. Public service. You see. When? You look into that.
Yes, Your Lordship.
But otherwise, I'm satisfied. One thing, that the labor court's order has to go. Now the question is, this court pass a direction for
Reinstatement or
Reinstatement?
compensation.
or
Okay.
taking into account that this is an allegation of misappropriation. Okay, heard Mr. S. Chakraborty, the learned counsel appearing on behalf of the petitioner, and Ms. So-and-so who appears on behalf of the respondents,
Respondent number 2.
respondent number 2. Mr. S.R. Bolwai appears for the respondent number 1. The matter had been heard in its entirety. However, during the course of the hearing, a question arises that even in the circumstance this court interferes with the order of the learned labor court, what relief can be granted to the petitioner? Taking into account taking into account as to whether the principles laid down by the Supreme Court in the case of as regards loss of confidence would apply. The counsels appearing on behalf of both the parties submits that they would place necessary precedents, PREC precedents in that regard. List this matter for final disposal on before Puja.
23rd is a Tuesday. It's a hearing day. Lordship may take a 23rd.
No, it will take 15 minutes. 23rd. No. 23rd.
At 2.
Okay, 23 at 2. Showing it as part of. You have to, and you also look into it as regards this connection with some judgment, not with that's all.
Much obliged.
Yes, what is this?
May I please, your lordship. Lordship, in this petition, petitioner has assailed the order passed by the appellate authority for a Assam Power Distribution Company Limited, which is at page number 100, annexure O. So before I begin, I just want to briefly state
This is regarding what matter?
they were tempering of the meter, alleged tempering of the meter. So the appellate authority rejected the prayer, and the demand was served upon us thereafter to pay. Thereafter, we have come before the honorable.
What is your ground?
Grounds, basically, Your Honor, Lordship will see there are multiple grounds from the very
multiple grounds is no. What is your limited ground?
Your Honor,
This court is going to exercise a social jurisdiction against an appellate authority's power.
Yes, Lordship.
So you have to show me perversity. What is your perversity?
Perversity is like, Lordship, there was actually no tampering and no evidence. But these aspects were not considered. And one more aspect that when the assessment was done, in one of the month, the consumption was given at a higher rate. But this aspect also was not considered by either by the area manager nor by the appellate authority. So thereafter, they have rejected my claim. I will.
Some seals of the meter cover of meter number so and so made secure were found broken.
Yes.
Was it broken or not?
Some, it was, they seems to be broken.
There is no seams.
I'll take your lordship to page number.
The question of fact.
Yes.
Seals have been broken.
Page number 72.
So the meter was taken for further investigation at the, and after proper resealing in presence of the consumer's representative. On so and so in presence of the consumer's representative, the meter was reopened at MTI month and removed the top cover of the meter and observed the extra foreign circuit elements were present inside the meter. This clearly indicated that the meter was tempered and confirmed by CMRI data analysis, where it was recorded as meter cover open, temper indication since 11/4/2013, so and so continuous. As such, so and so served the provisional assessment bill. During hearing, the learned counsel raised whether for the projected case of an unauthorized use of electricity can be made by applying the provisions relating to theft of electricity, that is by applying so and so, so and so. On whether for the projected case of theft of electricity, the assessing officer is competent to undertake any financial assessment, final assessment where such power is exclusively, this I have already answered. Whether in absence of any evidence, materials or explanation as to how any foreign element can be inserted, this is also goes. Whether the story of detection of extraneous inside the demand is demand, whether the absence of any plausible explanation as to how the meter can be controlled through remote from outside without the knowledge of the base computer software, the assessment can be sustained. In response to that, from the above, it is observed that direct evidence like inspection report, HAM report, and presence of foreign circuit inside the meter by breaking the meter cover seal indicate a clear use of malpractice. Moreover, the appellant is responsible for the safe custody of the meter inside its premises as pursuant. In view of the ban, I do not find any error, and bill question of Iman or more than 12 months. Is directed to restrict the period to 12 months and revise the bill for payment by the appellant after adjusting the payment made at the time of filing of the appeal. The bill is disposed. Then thereupon the final bill has been given.
Yes, Lordship.
How much? 1 crore 35 lakhs? Huh?
It's 13 lakhs, my lord.
13 lakh 58,000.
Yes.
Has been given after making that adjustment. So you have done it, Mr. Chaudhary, you have already done it in terms with this, I suppose, whereby last 12 months thing has to be taken from the date of the inspection.
Yes.
Whatever amount he has paid in the meantime
Has been
to be deducted.
adjusted. Yes, madam.
And what is the average prior to this has to be taken?
Yes, madam. Now, the issue as far as the initially, my lord, the appellate authority actually found.
You've seen my judgment in Kachar alloy.
My lords, I have had not had the occasion to go through that.
That's
Mr. Pathak was appearing in the
Have a
matter.
look at it, both of you.
My lords.
I think 4 or 5 of the issues are all.
Yes, my lords.
It was a case where there was an assessment being carried out. It was found tampering in the meter. It was a case of theft which was being done. The issues involved out there, that there was a question is that the seizure was not made in accordance with that. I said that question of seizure is for that particular, because as practicable as so, which is mentioned in section 135(4), has to be interpreted as in respect to when it is a case of mens rea, the seizure will be looked in terms with section 100 of the CRPC. Otherwise not. That is one. Number 2 is as regards the question of meter tampering question. It is a finding of fact which, unless there is any perversity to that effect, the question does not arise.
Yes.
Number three is how it is to be calculated. I have given that is one clause out there in your regulation. The last, that particular meter, the case of, yeah. You can go to regulation. Come.
Well, here we are governed by the regulations of 2004.
2004, okay, 2004 regulations will be there. That regulation is not there. But anyway, that is how it is to be done. Then these are the 3-4 points which have been taken care of. And this will be covered.
Lordship, in my case, there was no registration of FIR also in meter tempering.
Good. You should be happy.
No, Lordship.
You don't need to go to the jail.
No, Lordship.
I said the question is, I followed the judgment in Sitaram Rice.
Sitaram Rice Mills. Yes.
And there is another judgment thereafter recently in 2023 or 24 or something.
Orion.
That is another judgment, recent judgment.
Orion Metals.
Huh?
Only Orion Metals, madam. Orion Metals.
Yes, Orion Metals.
Yes.
Wherein it says, in respect to he is referring to the provision of 154.
Yes.
154 is there, but that does not stop them from making the provisional assessment or the final assessment.
Yes.
And the final assessment, if it is made and later on the special tribunal or anything gives a lesser amount,
Can
then
be-
it will be lesser.
My lord, yes.
But for that, it does not.
My lord. But in my case, Lordship, there was no test done that whether there was tempering or not. But yes, Lordship.
They had taken the meter and it was found.
No, that's what I would like to place that fact before you, Lordship.
What is that?
Yes, Lordship means, first of all, I would like to state that the meter cover in which they have stated that the seal was broken was inside the cabinet box. And the cabinet box is covered by meter terminal cover. Further, there is an optical port. There is no finding by the authorities that any of the seals were broken. It was only inside the meter cover, there was some seal broken. That was the only finding given. Suppose the meter cover is covered by the cabinet box. And thereafter, there are meter terminals and optical ports. There is no finding to that effect. That's why I take your
So
lordship.
here the CMRI report is what?
No,
Let us see the CMRI report. Where is it? CMRI report?
It's not, it's laid open. Not given. It's not. No, I have the records, my lord. My lord wants to. It's not, in the affidavit also, they have not provided the CMRI info. That's what I would like to take your lordship to page number 73.
As per inspection report dated so and so, the seal affixed over the meter cover, optical port, and more particularly the seal affixed over the cabinet box were found intact. In as much as no adverse remark whatsoever was made regarding the said seal. If that be so, kindly apprise as to how any tempering can be done to the meter by the consumer even without breaking the seal affixed with the cabinet box. If any such tempering was possible, whether any observation in that behalf was made in the inspection area. Seal was in broken condition. As per column number 4 of the inspection report dated demand, particularly so and so, the circuit area meter readings were recorded. How do you know that about this thing? Where's the report?
Report,
During
page number
the
73.
CMRI meter cover open tempered was recorded.
Yes.
If any extra element foreign circuit was inserted subsequent to the installation of meter, why the same was not diverged but CMRI downloaded on so and so odd Iman, meaning the extra element so and so is nothing but the original circuit based at so and so. Is it correct? And if not, clarify your stand as to how the same was not reflected in the meter cover open tempered was recorded. Now we'll need to look into that particular report.
Yes, and moreover, Lordship.
That was the report of the CMRI report.
This is the basis.
Yes, yes.
You have it?
They
I
have
have it.
only relied on this, Lordship. If I
Let us see.
one thing, one Lordship, page number 73. If
Yes.
page number 73, your Lordship may take point number 5. There it has been specifically stated seal particulars. Meter cover broken, seams broken. Meter terminal cover, no finding, it's intact. The cabinet box is intact. CT, optical port, all intact. Nothing is there. And the other cover, everything has been intact. Only inside the meter cover, some seals has been broken. And it is the
Where?
My lords, the flag number 4, my lords, is the CMRI data, my lords.
Cover open unspecified cover start.
Yes,
Line
there is a date mentioned at the left-hand side, my lords. The date is
11/4/2013.
Yes, my lords. There is a time also mentioned.
Then
It continues, my lord, thereafter.
voltage so and so. This is the report.
Yes, my lord.
Yes.
And
where does it say that it is open?
The CMRI report at that very page itself, my lord, at flag number 4, on the left-hand side, it says meter open.
Where?
On the left-hand side, my lord, that report itself at page, at flag number 4.
Cover open.
Yes, my lord.
Meter.
The cover has been opened by them. Initially, this date was taken to be the date when it comes to ascertaining the compensation amount or the assessment amount, my lord. The appellate authority decided that yes, no, you cannot take that as the reference point. You have to restrict it to 12 months. So this date was thereafter revised, my lords, and it was taken from the date of inspection.
The reporter does not categorically say, and it has been sent to what is the CMRI business?
CMRI, my lords, it's a short form for
common meter reading
comparative meter reading inspection data.
Huh?
No.
It's comparative meter reading
it is
inspection
wrong.
data.
It is
But
wrong.
it has not been sent to the FSL or anything.
Nothing, Lordship.
No,
No
the-
test reports are there, Lordship.
If I may submit, my lord.
Please.
This is the data that was collected, my lord. This is available for all electricity meters. Now, on 15/9, in the presence of the petitioner's representative, the meter was open.
By whom?
By an agency, my lord, an outside agency, an empanel contractor of the APDCL, who also takes care of all meters, my lord. The flag number 1 are the photographs of that very day, my lords. Yes, flag number 1, my lord. At the right at the beginning of my lord. Colored photographs, my lord.
Flag number, not.
But right at the beginning of the file, my lord, the first page itself. Yes, my lord. Those.
Got it.
Yes, my lord. Those are the photographs, my lords. My lords will see the meter number in question, my lords. It is LZ13466, my lords. It appears, my lords. It is also reflected in those very photographs. LZ13466, my lord.
It's a different.
Very difficult.
No, meter number to key as well. I'm sorry. Yes, yes. No,
It's a different meter number.
no.
LZ 13865, page number 873.
Which page?
Page number 8.
Huh?
No, I'm sorry, my lords. The meter number is AS897 851.
AS 097
AS897 851, my lord.
Yes, that I got.
Yes, my lord, that is the meter. That is the very same meter that is mentioned in the inspection report also. My lords, will they see in that while the meter was open, what they found were all these electrical wires that were connected through a black tape, my lords. This is the
black tape.
the black tape that appears, my lords, on the first page, my lords, the two photographs there, my lords, connected to the yellow wire, my lords.
Okay. Then
Now on that next page, my lords, will see again, my lord. Otherwise, the meter, my lords, when when there is no foreign circuit or anything involved, it is a clean process. All we'll see are the wires, my lords, and the I don't know what these are called, those welding points, basically, my lords. So there would be a circuit, and this is the foreign circuit, my lords, which is connected through this yellow wire.
But how did they open it?
It was bypassed, my lord.
Huh? What is that?
All right, it was according to the instructions I've received, they bypassed it. The cover was opened.
How? The seal was not broken.
Two seals were definitely broken, my lords. The remarks may be seen.
It's for meter cover. The seals which is
No,
stated is
my
for
friend
meter
would
cover.
Extend the courtesy of not disturbing me, my lords. The seals, my lord, inspection, some seals 13466 and PO 4733 are found broken, and the meter is taken for further examination, my lord.
Where is that?
No, that is part of the inspection report.
Where is that in
72, my lords.
72? Because of this case, the file has become so big. This has been going for a long time, nah?
Yes, my lord. Now, the meter cover, my lords.
This is the inspection report. And like page 72.
Page 72 is the type copy.
Okay. Consumer number, date of inspection 18/8/2014.
My lords.
Type of meter HT so and so. Average meter number is where? Oh yeah. AS 897231.
Yes, my lords.
No. Meter number AS
7
7851. Which
7851.
meter?
Yes, my lord.
Oh, this is you have changed it. Earlier it was 897851.
My lord, it has remained the same, my lords. Now, after inspection and meter is new meter is
So the
installed.
next one is the year.
Yes.
Present status of the meter, equip voltage meter, terminal current if meter so and so. All seal particulars, meter cover.
Yes, my lord. Now, my lord,
Paper
will-
seal broken.
Broken.
Seams broken.
Yes, my lords. Now, these
So there are two seals.
two seals.
One LZ 13466 has been broken.
Yes.
PO 4733 seems broken. Meter EC so and so, so and so. As per the letter dated so and so, the following site has been visited by the undersigned and on the inspection some seals. So and so were found,
Broken, my lord.
are found broken, and the meter is taken for further investigation by Secure Meter Limited. After proper sealing by the C division, resealing is done by the paper. Seal number so and so, so and so, and so and so.
Yes, ma'am.
Consumer, I was present during the above inspection, checking and verified and found correct the data and comments on the Sharma. So this is present. Then what are the minutes of the investigation? On 115 on so and so, the meter was carried out in presence of the consumers and so and so and so and executed his technical staff may to attend the dismantling. Meter cover is opened up and photographs of the various made so and so is taken and observed that the extra foreign elements. This is done by.
My lords,
Okay, so in presence of these two authorities were there.
Yes, ma'am.
Amit Sharma and Sandeep Sharma.
Yes, my lords.
Wherein it was noted the meter cover open temper events have been recorded continuously since so and so month. Meter is open. So there is the signature of Taksri. Notice to be served before 7 days of disconnection. So you are going for disconnection means you are doing it for theft.
Yes, ma'am. Well, disconnection was thereafter stayed. There was no permanent disconnection.
Okay, I'll rise today. Interesting. So when can I have it? As we have started, we need to finish it off. Tuesday.
My lords, as any day convenient to my lordship. my lords.
Tuesday.
Sign us on it.
Problem is you don't get time now.
My lords.
Before the vacation. that's
Yes,
you
ma'am.
taking a
And
bench
next
for-
week, again, is the motion week, my lord.
Motion week and it's a bench for bench for it takes a long time. Anyways, this court have heard the learned counsels appearing on behalf of the petitioners as well as the respondents and have also perused the records. So it is the opinion of this court that a further hearing would be required in the matter for the purpose of culmination of the proceedings. Accordingly, list this matter again on
23rd, my lord. 23rd.
23rd. I've already fixed one. It's a motion week. Let's see. On 23rd at 2 p.m. Let's see.
The list item 1 for admission.
May I please, Lordship? Lordship, by the last order, the state respondent were directed to file affidavit on or before 15 of this month. But Lordship, we are unable to file the affidavit. So I pray for some more time so as to file an affidavit.
Number 1 going on.
Lordship, not only the state respondents, the registrar of this honorable court was also directed to file affidavit in opposition.
Yes, your lordships.
Yes, Mr. Jimumi, we are taking up the matter after
Yes,
this.
my lord.
There is another matter we are taking up first.
Okay, my lord.
Yeah.
Okay.
Yes, Mr. Monto.
My lord, in pursuance to the order dated 21/8/2025, some query were made, my lord. Para 12, my lord. Para 12. To bring the position of registry is to call for a report against the SWB case plan reconstruction. So accordingly, my lord, some report has been submitted probably in the file, my lord.
Consolidated report.
Column number 5 is reason for delay, and the extreme right is, my lord, how to trial court proceed with the DGS. How the trial court process to dispose of success that as earlier.
Majority is there. Okay, so we leave the copy from Mr. Fupan.
Mr. Pupan, you have a copy of this? No. The consolidated report.
That is as on 31. That is today's
No, I think he will not have. It is pursuant to our earlier order.
earlier order.
And Mr. Mohanto, what about the detailed reports by this is a consolidated by registry.
My lord.
There must be some reports from each of the courts.
That is.
My lord,
Based on which
they have. it is
these
not-
are there.
It is not.
This is consolidated, huh?
On the basis of that, is compilation has been made. So
So your lordship kindly see reason for delay and
Majority is non-attendance of witnesses.
yes, my lord, and I have find out some 4 or 5 cases, my lord, there is stay there from this honorable court.
Ah.
And that will also, my lord, those matter may be, my lord, asked to list before the honorable court because of the stay order, some not been proceed, my lord. And my lord, in some case, I have seen that complainant not present. Complainant is not present, there are 2 procedure, either 256 or 249. They can proceed, my lord.
They can proceed.
And some cases, my lord, accused not present, my lord, one, my lord, I have seen, serial number 4, my lord, your lordship kindly see. Serial number 4, that case is, my lord, since 2008 case is pending,
Kindly come to 37, 38, 39.
my lord.
37, 38, 39.
Yes, my lord, 37, 38, 39.
So
That
what
they has given that short by giving short there.
what prevented the trial court to proceed?
In complaint case, these are CR case. If it is summon case, summons, then my lord, they can, my lord.
All these are defamations, I can assure you without
Maybe.
going through the record.
No, okay. There are more in here.
Mr. Fukan, we'll direct the registry to serve you a copy. Just take note of it. Most of the cases, except the CR cases, either steps not taken, not someone's issue, so it is part of the prosecution.
But in meantime, my lord, in between this 1 month, I have already communicated to all the SPs and the TPs of the district, my lord. When I communicated with they have furnished some report to me also. In each and every district, my lord, they furnish their report. Why the cases were delayed and what are the reasons? They have, my lord, they produced some status reports to me, my lord, and I have collected from each district. On my lord, some cases, my lord, complainant not present. In some cases, my lord, the someone was not executed. In some cases, my lord, they had taken immediately adjournment. These are my lord, the reasons the cases were delayed.
So how to now we need a path ahead.
Yes, I have already, my lord, instructed all the districts also give any the adjournment. Even, my lord, the ADGP, CID also, my lord, communicated all the SPs to take care of regarding the warrant summons and, my lord, the and BWs. They have to properly take care of it and not to, my lord, the lapses on part of their, my lord, the IOs.
So we propose you to give you the, now we are having the detailed report. So you compare with your one and give a proposed course of action, Mr. Mojumdar, you also. Mr. Mohanto. It's not an adversarial litigation, we want to finish off.
Monitoring only.
Monitoring only.
In Sribhumi district, my lord, there are 3 cases. So 3, my lord, 2 were stayed by the High Court and 1 is disposed of in. And 1 in Nagaon case that was withdrawn. These 2 developments are there, my lord, in between.
Okay.
In between, probably last month.
There are, my lord, 6 numbers of cases by the High Court. Where 1 is registered on 20. This is Joharhat PS case, my lord.
Pending before the specially assigned bench
Yeah.
is 5. 1 is CAV and 4 pending and some other which I cannot take. So that has gone to the others. If there are some fresh cases, we are not aware. So hopefully by the next date fix,
It will be,
Hmm.
it will be disposed of.
it will be.
In High Court, considerable progress has been done.
And moreover, by that one, which passing is elections, take necessary step by the then it will help for me to my communicate with all the.
We'll pass that order, but not on the next,
Not the cases there.
on the next date, on the next date.
Yes.
Let them compare the two reports.
That is what, that is what.
In between, there may be some gray area which your authority will
Ah.
pass appropriate. for.
On the next date, taking note of your views
My
and
lord.
all stakeholders' views, we'll pass and
My lord.
just give us a suggestion and roadmap. You have your datas. So based on these datas, what is your analysis and what should be our next course of action? Path ahead.
Moreover, my that we have suffering from one problem. By the all the new TPs will come.
Hmm.
There is a transition period. We think we are less interested by that. We are also suffering with that. They are not expecting big. They are less interested now.
Because
the
they-
permanent cadres will come.
They will be replaced.
by the-
They will be replaced.
by that. So that's why they are also not interested now. We are also suffering.
And they will work.
In this thing, we have forced them to do the work, but they are less interested.
Are you clearing their bills?
By that.
Are you clearing their bills?
Yes, but
Anyway, I will go to the next matter now.
My lord.
What do you think?
The mobile बनाओ ले बरे. Done.
It's
23rd
we'll have it on 23rd
October.
October.
My lord.
third matter.
Pursuant to the order,
3rd October.
pursuant to the order dated 21/8/2025, the registry of the registry of the spot have prepared a consolidated report of the pendency of the criminal cases against the sitting former MPs MLA on the basis of the suggestions which have been also given, provided by the
23rd.
learned trial courts. We have perused the said consolidated report.
20.
We find it expedient that a copy of the said report be also furnished to Mr. M. Pukul, the learned director of prosecution, Assam, so that he can also give a suggestion as to how to proceed with for an early disposal of these proceedings. So accordingly, we fixed this matter on 23rd of October 2025 at 2 p.m. So we further observed, we have been further apprised by Mr. M. Pukul, the Director of Prosecution, that he had also made certain inquiries with the public prosecutor, learned public prosecutors of the district courts, wherein they have also provided certain suggestions. These suggestions should also be placed before this court by way of a consolidated report. List according.
Deeply.
What?
Yes, Mr. Insong, Mr. Jimomi,
Yes, my lords.
and
My
Mr.
lords,
For orders.
Yes, that is, Mr. Jamir, your case is for the purpose of, can you hear me?
Yes, Lordship.
Okay, your case is for the purpose of creation of more posts,
Yes.
and more particularly the post of the court managers, which are absent out there in the Kohima bench.
Yes.
And Mr. What is your stand on learned additional advocate general?
Lordship, as per the last order, I was supposed to file affidavit on or before 15th of this month. But Lordship here, I received instruction only last evening. So, Lordship, I seek some more time so as to file an affidavit in opposition.
Okay, we'll look into this. Now, let us first look into what is the stand of the PWD as well as the finance department. Mr. Imsong will also look into the building infrastructure as regards the High Court building just after some time. You take your seat. Yes, what is your stand as regards the toilets as per our last order?
Lord, you will see the chart. Tender process has already been initiated, my lord, in almost all the districts. And in some of the districts, the works have been completed already. Lord, you will see serial number 6, 14, 26, 27, and 35. Works already completed.
Finance allocation have been done.
Yes, allocation is there. In fact, finance has stated that the moment the work is completed, bills are submitted, it will be approved. That I instruction, they are waiting for the final bill.
Code 09.
What about 23?
Yes.
PTC, my lord. Code of conduct, my lord. My lord, serial number.
Yes,
23 and
who is there
20
for the registry? You are there. What is the status of the Udalguri District Court building? How many years does it take? Would it have the same fate like Nagaland? How many years has it taken for the Udalguri District Court building to be completed? What is the status, Mr. Das?
Udalguri, my lord.
District Court.
Dangor.
You inform us next time. We are putting you to notice about the all the other district courts wherein the constructions are going on. We would who is to so oversee? It is, I think, the district judge. There's a committee of the district judge
Yes,
along with
yes.
the portfolio judge. This is
Yes.
being done.
Yes.
Now, what is the status of these? Wherein
sir.
it has not yet been completed?
Udalguri to yet include kona. Okay, I understand. No, this is with regard to the original issue, which, Milord, remain dormant in between due to the toilet issue, Milord. In fact, in regarding the original issue of Milord judicial infrastructure, Milord, report is already there before your lordships, Milord. It's a bulky report, Milord.
But we need.
We haven't deliberated on that, Milord.
No, but we need an updation.
I understand, Milord. I have already instructed Mr. Devasis that to upgrade it.
Because there are new proposals.
Exactly.
Pending before the chief engineer's office, PWD.
Yes.
Huh?
Yes, Milord.
In
In fact,
somewhere it is not even come from.
yes.
So
In between, Milord.
we'll go on the next day.
In between, Milord, something has also come. Milord, infrastructure has also been completed. Construction.
So we need-
All those will be included.
Give us a consolidated report as not this bulky one, like the similar thing which has been done in MP MLA's case as
Fine.
regards each of the districts wherein the constructions are going on and how many people, what is the period during which the constructions have been going on and when it is to be completed. Have you taken any undertaking from the contractors for completion? These are things which we will require.
We'll give the entire thing and we'll also prepare small 2-page thing, Milord, so that your lordships can read that and have an idea what is there inside. Milord.
Yes. So here toilets are moving. So when how many years, how many months do you propose to complete these PWD?
We will post it after 30 days.
No, that will post it again on another
In
day.
the meantime, my lord, already, my lord, they will give a instruction to all to my lord to expedite the. Because these are repairing and innovation work, renovation work, man, majority.
New also?
No, some new, that's why majority of the works are renovation and repair. Won't take much.
Okay.
এই
You,
গোটেই কি
that is
35
one.
টো নে
Now, what about the other building?
Got that report I
CGM.
submitted.
Hey.
Tender has been issued, my lord, almost 60% work already over, 55%.
কোনটো
Revenue.
ৰেভিনিউ শিফটিং হৈ গ'ল CGM তো ফেৰি গ'ল GAD বিল্ডিং তো GAD আসাম টাইপ ঘৰটো কি হ'ব নহয়
Have you made the arrangements for the bar members to sit?
That once, my lord, this boardrooms will have to be, my lord, first.
Then you want to keep that bar building there?
No, that, my lord, Assam type building within the camp. For that, my lord, it will be allotted. But this construction work, my lord, renovation work, whatever is there, my lord, because we'll have to now, my lord, formulate this, my lord, boardrooms.
So
In
there
the
will be
floor.
only the revenue board will be there, na?
Yes.
As well as the administrative tribunal.
Not civil, administrative tribunal is presently occupying second floor, which will be shifted to the first floor, and the balance work of Swenso will be started. In the remarks column down below, man.
No, it's okay.
No, in the first floor, CGM office, Office of the Assam Board of Revenue,
Yes.
and Office of the Assam Administrative Tribunal.
Well,
And Board of Revenue occupying second floor,
got it.
is not it?
Yes.
So second floor, they need to vacate. And shifted to the first floor, and balance work of CGM office will be started. So this is the hindrance as on that.
So, my lord, so far as this particular setup will have to be, my lord, whatever is
Whereas-
presently, my lord, vacant, that they will have to, my lord, first of all, my lord, construct it. By, my lord, temporarily, and then it will be shifted.
My lord, I have also given a minutes that will give some insight, my lord.
এই কপি এটা দে না খাওয়াতে এত
There were other departments, have they vacated?
I don't think so, sir.
So far as the.
No,
Pranam-
earlier we were
Pranam
informed
Commission
that.
is concerned, my lord. They were there, my lord, they vacated. And for police commissioner at Guwahati,
My lord,
it was to be shifted to the premises, they've taken a decision along with the secretary, there was a meeting. my lord. And, my lord, it will be shifted to the Assam official language TCL commission at Joyanagar, Belton. Five, my lord, but next year, all these things will be over.
second page, there is a resolution.
এটা কপিটা দেখুন বানতে দিতে যদি বলতে
So Pranam Commission has vacated.
Yes.
But these meetings say something else.
When it was the 8-9, which is the meeting.
8-9 meeting, if you see the agenda number 2, you are having the. What?
I have given,
This
I have given.
particular commission, Pranam Commission, in the first floor, which will be the CGM, the administrative administrative tribunal, as well as the other one, Board of Revenue.
First floor CGM office, office of the Assam Revenue Board, and office of Assam Revenue Administrative Tribunal.
So they have not vacated. As on 8-9.
এইটো মাইনাস করুন রেজুলেশন
2 number. Agenda 2.
They have not vacated, Mr. Gogoi. It is your, whatever your instructions have been issued by the chief engineer does not appear to be accurate. By this executive engineer, does not seem to be accurate.
He has only provided this.
I think the government is not in a hurry with that, no? That infrastructure, the park and all, you are not in a hurry, I suppose.
No, they are in a hurry, my lord.
No, they are not in a hurry because otherwise why the particular department is still functioning out there? Because we may have made it very clear that you cannot touch the building till you accommodate the lawyers.
Yes, yes.
So therefore, the question is, if your one of your departments still continues to remain, and you are not giving them the space, the worry out here, we have no problem in shifting them from there, but provide some space.
Accommodation will have to be given. Of course, my lord. In fact, my lord, the police commissioner will be shifted to the Assam Official Language TCL Commission, so they have found a place. Assam Official Language TCL Commissioner Joyanagar Beltola, as confirmed by the Commissioner of Police. So
But
it will be-
Pranam Commission, they are still there.
That's the my lord confusion. One minute was held in my lord 7/10/2024 itself, where it was apprised that the Pranam Commission has already vacated the GAD building.
No, last time also it was told that they have not vacated. That was the problem which was being faced. So your instruction on 20, as we have sought for, is not complete.
Apart from that, my lord,
Regarding the second floor.
Second is not complete. So therefore, what is happening is second floor with them being there, and when this revenue and Assam administrative building revenue is not there. Assam Board of Revenue is not there in the second floor.
It says the Assam Administrative Tribunal is presently occupying the part of the second floor.
So only so Assam Administrative Tribunal is there, not the Assam Board of Revenue.
No.
Assam Board of Revenue has to come to the first floor,
Yes.
as well as also the Assam Administrative Tribunal.
Sure.
So when is the Assam Administrative Tribunal is going to come? Unless you come, the second floor cannot be accommodated. And when for the lawyers you are making that accommodation,
that is important, my lord.
that is
Because-
silent.
Because for a moment, see the second part of this remarks says Assam Administrative Tribunal is presently occupying part of the second floor. This office will be shifted to the first floor and the balance work of CJM office will be started.
Understood
That
when?
part is construction is going on, my lord. They have stated.
No, they will shift, which is in future.
No.
And
The-
then it
above
will
the-
start.
No, above that, Lord, you will see works under the CJM office at ground floor and the first floor is 80% completed. Second floor, 30% complete.
So therefore, they are not in a position to shift.
That-
But what about that, the commission, that commission has to,
That will have to be, my lord, she will give a, my lord, short time to the authorities. They will, my lord.
chalo,
But
this is.
next day, that will.
So
Another
as regards all the other infrastructures which are presently going on, will require consolidated, not affidavit and a
Report.
chart.
Yes.
What is the status?
Yes.
What is the, when the work order was issued?
Yes.
Date of actual completion?
Yes, ma'am.
What is the status?
Yes.
When it is like to complete it?
Yes, ma'am.
Whether finance is the reason?
Yes. That I'll prepare and I'll give it before the next date.
And reasons for delay?
Fine, ma'am. Fine.
Will please.
Lord, one more issue,
In the report, my lord.
Lord, one more issue here, so far as to accommodate the lawyers are concerned, my lord, in the minutes, my lord, in the first resolution, your lordship will find two things were discussed, either to erect a G+3 building
No.
It's, Lordship will kindly have a look.
These type of
No, no.
things cannot happen.
No, that is not the final thing. Deliberation was made either, my lord, the minutes I have given to you, Lordship.
In this regard, registry may move the government for.
Today's meeting resolves that a proposal so and so, here in between middle, either to go for a building or to, my lord, improvise the existing Assam type building, Assam type house to 2 floors. It can be done, my lord. Because even though this is a temporary, but it will take 5 years.
Which one?
Look, this, to accommodate the lawyers.
G+3.
No, I'm not saying that. That is one of the aspect. Another option is that the existing Assam type house, which is there already in the campus, my lord, it's a quite large one, my lord. The height is sufficient, so it can be converted to a, my lord, duplex.
No. Don't go for all this duplex business out there. It will take a long time.
No, it can be done, my lord.
How much time?
How much time?
No, duplex means I'm not.
No, please accept it. How much?
My lord, that PWD will be able to, my lord, convey, but the thing is that it is a possibility to accommodate the lawyers in that particular.
See, one aspect, another aspect of the.
I'm sorry.
Do you expect that this CGM will be permanent here?
No.
So
So
if
that's
no, why we spend so much of money in 3-story building?
lord,
Let
if
us
I-
have the bare minimum.
My lord, 3-story building, I am not suggesting at all, my lord. I am not suggesting at all. This will be if we upgrade the existing Assam type house to a 2-floor.
Give a report that this is possible.
So that
within
has
such
already
and
been,
such period.
my lord, the PWD representative was there in the meeting. It was suggested by the PWD itself. We have not suggested. If your lordships kindly go through resolution,
Where?
in that case, the record so and so, my lord, it says allotted without damaging the.
Presently situated within the campus of the GSA, which is being used by the Assam Rotary to stock their factory. The multi-story building to be erected.
Second. Yes, without damaging the present structure, there is a possibility for construction of another floor within the, as the height of the building is adequate.
They will put wooden plank.
It like trust,
Temporary,
steel truss and flooring, and it can be, my lord, it will accommodate more advocate.
Let them.
They can look into that. That will be a.
Lordship has, I think I can share, your Lordship has the, your Lordship has seen that building. Slightly, height is slightly bigger.
No,
In that is-
No, Mr. Muzumdar, are you referring to that old building?
Yes, my lord.
How is
This
it
is
possible?
what they are referring to.
No.
Please, my lord, for it's a different thing.
One floor, it's not.
And
a-
tomorrow, any mishap happen.
That building.
Yes, in
Who guesses?
My lord,
Assam Administrative Tribunal I had been, and to the nearby Assam type house I have
that is
gone.
what I'm saying, whether your Lordship has.
No,
physical,
if it's
knowledge
not
of-
possible, then all right. I have presented. because
No. First, you see, we cannot just put these the lawyers out there, just throw them in.
No, cannot be.
No,
Cannot be.
they have to be also given conducive space,
Atmosphere, yes.
atmosphere. But the thing is, you cannot do it in this manner. And life and safety of the lawyers are also very important.
That's true, Miller. That's true.
So therefore, we cannot allow these type of things cannot happen. They have to make something. They have to request the lawyers how they arrange what is there. The PWD has to, but still they don't do it. They cannot vacate these people.
Yes.
And they must have forgotten, I think, about the beautification. They don't want it. We'll have it in 2029. We're having an election 2026 now. 31.
Let it be on 30th of October. Some progress will be made.
Okay, you'll see that. That is one. And as regards the yes, what has happened to the Kaziranga guest house? We see something mentioned out here. Anything done? Yes, PWD. Anything? Any idea on the Kaziranga guest house? There was some meeting out here.
Yes.
That's just a reference. That's why.
Just a reference we are making.
Yes.
Just take a note of it. Okay, we'll pass an order on that.
Yes, sir.
Okay, so here we are done today for these. You, as regards the other constructions which are to be done, you make the consolidated sheet, we'll pass it in an order specifically giving.
Yes,
that.
yes.
Now let us hear the, where is the Advocate General of Nagaland? Madam, what is the, you are aware of it, that there has been certain changes to the High Court building there. The earlier High Court building, which was to be with the chief and 6 other courts, have now been reduced to chief with 2 courts on either side. And the last 2 courts on each, on the opposite sides, could be used for the bar. So this takes care of the bar's building, which is otherwise, I think they are proposing to put it for the MTS, multitasking stuff. And the first top floor to be used for the bar. That was the proposal which was being submitted. And I'm told that there is some development on that. Any idea on that aspect?
My lord, I am asking and praying for an accommodation. Actually, he has contracted with some infection and
He's in?
he's high dose of antibiotics and could not appear before any court, even virtual. So I'm instructed to take some time, and in the end, he will come and then he place it before. Or what it is, because in the other, in the last occasion, your lordship has asked for a timeline. So that is the petition they will give. He is recovering, but sometime maybe after.
Because last time when I was in Nagaland,
Yes.
there has been certain developments out there.
Yes.
Chief Justice has also had a meeting with the Chief Minister, and there has been certain talks in that regard, so that there can be a possible chance of having the inauguration this year. So that was what has been given an impression on the administrative side. But the thing is, you see, that these things have to be done. Otherwise, what is happening is the building is in a bad. If it keeps on, every time it is just being on a repair, it has now gone to a stage of repair.
Lordship.
You must have recently been out there. It has now gone into certain stages of repair. Certain things have now been broken, and all that civil construction otherwise is finished. Only thing remains is now is a bit. I think the transformer has also been done. The water has already been done. I think 80% of the bungalows are complete. Only 20% of the bungalows are there. And further to that, there is also the major issue is as regards the furnishing. And the furnishing has to act, normally other things have been done, but the furnishing has to come. But if it is doesn't moves now, it would take, there has to be a contract issued for the furnishing. And I'm told that the present contract does not cover the furnishing. When can your Advocate General advise us on that furnishing? When?
After the Puja holiday.
No, that is too long. That is too long. We may sit at 3:45. There is another matter only for this issue. Only to that. When the contract for furnishing would be issued.
Lordship.
Because without the contract for furnishing, it cannot proceed. Because once you float the contract, to take some 45 days minimum. Because you cannot go, if the state of Nagaland thinks that, okay, we can give it to them, anybody, you feel like it's a different thing. But I don't think they would do that. Only to that effect. As regards the contract for the furnishing. Remaining will look into it. We are looking into it. And I think senior judges would be going there for sitting out there in that Kohima bench for that for a long time. But we require it on this furnishing aspect.
Lordship.
The remaining part. Civil works is, I've seen the building, it's 98% complete, only very less, even all the. Wait. And we'll have it next Tuesday. Anyways, I have also another matter of the Advocate General fixed on VC on Tuesday. Can we have it on Tuesday? Just he'll appear on VC and gets us the instruction as regards the contract for furnishing.
He is not in the position, my lord, to come and.
Then you take the instruction from your chief engineer. Huh? We'll like the Advocate Generals to be present, but if he's not here, but through VC, because he'll be knowing it.
Yes.
Or if not Tuesday or Thursday, because Tuesday there is another matter which I have got it from Nagaland. From Kohima, I've got another matter which is fixed, where the Advocate General was appearing in Kohima and we fixed it on through VC on that.
I'm also told that he came in the beginning of this month and appeared before your lordship in Hima also. Then he got.
Yeah, I met him out there.
Then he's not.
So maybe because of that, but ask him if he can appear through the VC and we'll have it on Tuesday. Good stuff. Okay, we'll pass an order and fixing it on Tuesday only for this furnishing.
Fine.
Remaining is okay. Other things, I'll pass that order.
Fine.
This will go again on 23rd for the other matters.
Fine,
But for this, I'm only just fixing it for Tuesday.
Fine.